Good evening. I'd like to welcome everybody back, and we will resume consideration of Bill 88, the Saskatchewan First Act, Clause 1, short title. I will open it up for questions. Ms. Sauer?
Thank you, Mr. Chair. Minister, will this bill, and if so, how, will this bill alter thresholds that allow industry and other sectors to have their projects expedited without consultation?
Thanks. I just was waiting to see if there was more to the question. The purpose of this bill is not about projects per se, which has been another important, I think, point to clarify and often comes up in the context of duty to consult. It's not a project-by-project bill. It's a policy regulations, legislation addressing bill in the sense that, and we went over that a little bit before the break, just some of the policies that we're seeing, and we've never really said anything otherwise. It's always been very clear that whether it's the carbon tax, whether it's the Environmental Impact Assessment Act, whether it's methane regulations, whether it's clean electricity regulations, whether it's EV regulations, again, and we touched on this a little bit before the break too, the federal government and courts have held this, do not have the right to specifically regulate specific industries. And that has been held consistently, and certainly Mitch can get into that in greater detail. We discussed this certainly in the context most recently of the plastic intervention at the Federal Court of Appeal, where the federal government is getting into an area of provincial jurisdiction on regulation, namely our environmental regulations in the province. It will create bureaucracy, it will create red tape, it will create cost, it will create duplication, but there are also very clear constitutional reasons jurisdictionally why that's an infringement. And so the answer really to the question is this a project-by-project thing or response? It's more in relation to policy and cost, economic harm of policies, and infringement constitutionally when it comes to legislation by the federal government of provincial jurisdiction. So I mean, obviously projects become byproducts of policies in the sense that, and I've mentioned the Saguenay liquid natural gas facility, which was a direct casualty of the Environmental Impact Assessment Act. Also, Quebec was not in favor ultimately, although certainly certain communities were, but Bill C-69 came into that. Obviously, we've seen the impact of federal policies on pipeline expansion and so on. But so there are project byproducts of federal policies, but the response of the Saskatchewan First Act is to assess the economic harm of federal policies, legislation, regulation, and their economic impact on the province, which is, as we've stated a number of times, substantial.
Minister, in your perspective, how do treaties fit into the Saskatchewan Constitution?
How do treaties?
Treaties fit into the Saskatchewan Constitution.
Well, I think we've been over this a number of times, and certainly happy to repeat the fact that, of course, within the Constitution Act, 1982, Section 35, absolutely enshrines treaty rights in the Constitution. And within provincial legislation, Section 243 of the Provincial Legislation Act does the same. It basically ensures and enshrines that treaty rights are intrinsic to all provincial legislation. As I've said, certainly the sense was that, and the legal reality is, the legislative reality is, that it is also enshrined in this one. In the Sask First Act, we saw an amendment earlier this afternoon by the member for Athabasca, an effort to having listened to concerns and heard those concerns to absolutely clarify, absolutely reassure, but legally in terms of the significance of treaties and their intrinsic presence both in the Constitution, under Section 35, and under provincial legislation. That's never been in question.
Minister, Indigenous rights existed before treaties were signed and predate the Constitution, as I'm sure you know. Section 35 of the Constitution does not give the rights to Indigenous people. It acknowledges the existence of those rights. Does this bill interfere with that?
And Mr. McCavan, would you, Minister by default, would you like to weigh in on that further?
Thank you for the promotion. The minister's answer is absolutely correct. This bill doesn't interfere with Aboriginal or treaty rights at all. As has been discussed earlier today, those rights are protected by Section 35 of the Constitution Act 1982. And as you point out, that gave those rights constitutional status, but those rights existed prior to that time and were protected by the common law. So this bill doesn't purport to affect those rights at all. When I'm discussing the bill with people, I describe it as a bill that deals with federal and provincial matters, as opposed to dealing with Aboriginal and treaty rights. And as the minister has pointed out numerous times already today, those rights are protected by Section 35 of the Constitution Act. There's nothing in this bill that takes away from those rights, and because they are constitutionally protected, nothing in the bill could take away from those rights. And in addition to the protection that those rights have from Section 35 of the Constitution Act 1982, they're also protected by the Legislation Act in Saskatchewan, Section 2-43, and as the minister has indicated, there will be a similar provision put into the bill pursuant to the amendment that was announced earlier today. So in our view, there's nothing in this bill that takes away from those rights at all.
Thank you. Minister, I'm going to quote from an op-ed that you wrote in the Leader Post on November 20th, 2022. You stated, quote, "Contrary to Leeson's assertion, we are not adding new powers to the Legislature of Saskatchewan. In Section 3, we are merely asserting and enumerating the province's exclusive powers. Sometimes, as Quebec policy analyst Michel Kelly-Gagnon recently wrote, a provincial government gets the powers it dares to take, not just the powers that are handed to it. In Saskatchewan, with our Saskatchewan First Act, we have chosen to undertake that dare." End quote. Minister, which one does this bill do? Getting the powers it dares to take, not just the powers that are handed to it, or, as you stated, we are not adding new powers to the Legislature of Saskatchewan?
Well, we are not adding new powers to the Legislature of Saskatchewan, as I stated in the op-ed, and as I've stated now at least 2 times this evening around that point specifically raised that I was responding to. And I've said and said then, we are not adding new powers to the legislature in Section 3. We are merely asserting and enumerating the province's exclusive powers, and we've gone over those a number of times. I think in terms of Michel Kelly-Gagnon's point and the quote you just read, he was referring to Quebec, and he was referring to the boldness that Quebec takes. And I think that's an interesting question. If we're going to talk about listening and listening to all people in the province, one of the things that we hear the most is we should channel our inner Quebecer and our inner Quebec. And I think one of the reasons that people say that is because, I mean, not only did Quebec unilaterally amend its provincial constitution, and we've talked about that a number of times as well, that Prime Minister Trudeau acknowledged that that's a right provincial governments have, but it was Quebec that did it. And I think that one of the most intriguing things about Quebec's positions on these things is that it can fundamentally agree with federal ideology and policy, but it'll always come down hard on exclusive jurisdiction for the province. And we get this a lot. I mean, I think it's fair to say, I mean, I believe the member has raised similar points along similar veins, variations on themes. You know, why do you take on the federal government? Why do you bother? And certainly the implication is always, and I resist this with every fiber of my, certainly of my political being, that somehow it makes one a bad Canadian if one challenges things, for example, around exclusive provincial jurisdiction. And it's distracting. There's a lot of talking going on, Mr. Chair. I just, yeah. So in response to the quote, I think it's important context that what I was really getting at when I stated or restated the quote, which is back on November 1 when we introduced the Act, it was about asserting. It was about asserting, which is exactly what we're doing, and it's what Quebec does all the time. And you know, the implication about, for example, the province of Quebec's raising some of these exclusive jurisdictional issues, and they raise them across the board, they are generally not accused of being bad federalists, whereas the West routinely is. And I mean, it happened as recently as the plastics intervention. It's why would you ever bother doing it? Why would you bother asserting your exclusive provincial jurisdiction over these things? Because it matters. Because it matters when there's infringement on provincial regulation that in turn impacts us, business, everyone in the province, and actually our own environmental stewardship, which we're very proud of and which we regulate. And so once you allow that to happen across the board, and the federal government to get into those spaces in regulation, for example, it's worth, we feel, taking a stand. That's what this Act does. And that's what I was getting at when I quoted Mr. Kelly-Gagnon. It's in that spirit that we hope the time has come to look at the core powers of provinces, and Mr. McAdam went into that a little bit before the break, the fact that this is about legally buttressing arguments around jurisdiction. And so in terms of channeling an inner Quebecer, I think it's really about saying these things matter and we're going to take a stand when it gets into infringement. Also around interjurisdictional immunity. It's a reality, it's an argument. It's something worth fighting for when it comes down to the economic potential of the province and the harm done when there is continual infringement and overreach. So that's what I was getting at when I quoted Mr. Kelly-Gagnon.
Minister, do you think the province can define the meaning or interpretation of the Constitution in legislation?
Do you want to take that?
What I would say in response to your question is, it's our opinion that the legislature can express its views on the meaning of terms in the Constitution, and as in this legislation, can express its views on matters like interjurisdictional immunity and what are the core powers of the province and what aren't the core powers of the province. Now, in our country and under our Constitution, there is a division between the legislative branch and the executive branch and the judicial branch. So ultimately, on questions of interpretation of the Constitution, it is the judicial branch that has the final say. And in our country, that's the Supreme Court of Canada. So ultimately, it's the Supreme Court that will define the terms in the Constitution. But as I said before supper, we think that this Act does make a valuable contribution to the debate, and that it shows that, you know, the elected representatives of the province of Saskatchewan in this legislature have set out their views with respect to the importance of provincial jurisdiction over things like non-renewable natural resources, the generation of and production of electrical power, those sorts of things. And we do think that that's something that courts can and will take into account as an interpretive aid. So ultimately, yes, you're right, the decision lies with the Supreme Court of Canada, but we still think that it's completely constitutional and valid for the legislature to express its views on those important issues.
And I'll also mention, if I can, Mr. Chair, I think just to go to the idea of the Economic Tribunal, which is an important offshoot of this Act, whether it always ends up in the legal framework, and again, I mean, with the carbon tax, we've been down that road and you know, are intervening in other cases. But I think it's extremely important for people to realize and for it to be trumpeted to the province, the country, the federal government, what the cost impact is of some of these policies. They are not theoretical abstracts. There is a cost impact. And so in terms of the Economic Tribunal, you know, based on this evaluation, this independent assessment and evaluation of cost, what then is quote unquote done with that information, and we've been over this a number of times, it could serve for, you know, toward an interjurisdictional immunity case. It could serve as a reference to the Court of Appeal. It could merely serve as information to the public. And I think that that is important to raise awareness about every day. I think it sends a very strong message that the number of provinces and territories are intervening in the Bill C-69 case that are. Again, not always provinces that disagree with the federal government ideologically. So why are they doing it? Because they feel that constitutional jurisdiction and exclusive core powers of the provinces matter. That's not just Saskatchewan. But I think we're part of an important team when we raise some of these things. I think if we live in this federation, and we've done this dance for many decades around division of powers, and I mentioned before the break, Peter Lougheed, but also Alan Blakeney, and it's been raised by the member's office a number of times when the bill was originally introduced, that actually it was Alan Blakeney who played a part in this, in terms of asserting exclusive jurisdiction under 92A. And I credit him for that. As I said, it was prescient because it was seen as a counterbalance to federal power, to federal overreach, and never have we seen the federal overreach that we see now. People can say, well, that's Fed bashing, but the point is we feel that it's important to raise the dollar figure harm of these policies and also raise the very serious issue of constitutional overreach. These are serious, grave issues with serious, grave impacts. And it would be irresponsible in our position to not raise awareness with every tool at our disposal, factual, legal, in this case constitutional, to sound the alarm about the impact of some of this. As I say, they are not abstract threats, they are real economic threats.
Taking it back to my question, Minister, I would like to quote a paragraph from the Supreme Court decision Vavilov, and I'd like your comment on that. It's, of course, we all know Vavilov, but it's 2019 SCC 65, and this is at paragraph 56. The Constitution, both written and unwritten, dictates the limits of all state action. Legislatures and administrative decision makers are bound by the Constitution and must comply with it. A legislature cannot alter the scope of its own constitutional powers through statute. How do you think this legislation fits in with that?
I'll let Mr. McAdam weigh in, but again, I would bring it back to Section 45 and the explicit right under Section 45 for provinces to unilaterally amend their constitutions. It's in black and white. It's been acknowledged, as I say, by the Prime Minister that this is possible, and Quebec has done it. It wouldn't be in Section 45 if it weren't possible. It's constitutionally enabled, and we did it. And in terms of the broader interpretation of what you touch on, again, I think to Mr. McAdam's points earlier, it all comes down in the end to judicial interpretation, of course. If it goes down that road, and we've seen that in a number of cases, we'll see where the Environmental Impact Assessment Act case goes one way at Court of Appeal. We'll see where it goes at the Supreme Court. I think, though, that we've been pretty clear, throughout the afternoon and into, the evening now about what we hope will be weighed in terms of legal interpretation, judicial interpretation of where federal paramountcy is going in jurisprudence, where interjurisdictional immunity we hope might go. And I cited a case from the BC Court of Appeal where it went pretty far in terms of a provincial enabling of interjurisdictional immunity. And really the word we've used a number of times is this buttressing, that we hope that in doing what we've done, there will be increased legal weight to achieving something such as an interjurisdictional, not interjurisdictional immunity, an interlocutory injunction, if and when necessary, when we deem necessary. So it all goes into the legal, jurisprudence package, but I think one case may say that, other cases weigh differently. Mr. McAdam.
What I would say is, to start with, the Vavilov case is an administrative law case, not a constitutional law case, so I'm not as familiar with it as I should be. But as far as the statement that you read out of paragraph 56 that says a legislature can't expand its own powers, I completely agree with that, and I don't think that this legislation is offside with that at all. We've said earlier this afternoon, and I think again after supper, that this act doesn't purport to create any new powers for the province. It simply is asserting the jurisdiction that we already have under the Constitution Act 1867, and in particular the powers under Section 92A of the Constitution Act 1867. And the other thing that I would say is that the Act is really trying to defend those powers from inroads by the federal government. And I know I mentioned the carbon tax case a little bit earlier, but I'll go back to it as an example of the type of legislation that hopefully this legislation can provide some assistance in dealing with in the future. When we started off with the challenge in the carbon tax case, the federal Minister of Environment and Climate Change was saying that the federal government had jurisdiction to pass that act because it had jurisdiction over the environment. And of course, the lawyers in our branch all gave the opinion, well, no, the federal government doesn't have jurisdiction over the environment. They can't pass laws simply because they affect the environment. The Supreme Court had said a number of times that jurisdiction over the environment is divided. So when it deals with a matter within federal jurisdiction, the federal government can pass environmental laws. But when it deals with matters within provincial jurisdiction, the province can pass those environmental laws. But then we found, as the carbon tax case wound its way to court, that what the federal government was arguing was not that they had jurisdiction over the environment, or not that this fell under the criminal law power or the trade and commerce power or their taxation power or any other federal head of power. Instead, they relied on the national concern branch of the peace, order, and good government power. And I've described that clause before as one that basically allows the federal government to amend the Constitution by going to court and getting the Supreme Court to agree with them. And their argument in that case was, yes, we agree that applying something like a carbon tax would ordinarily fall within provincial jurisdiction when it's applying in local markets, when it's applying to local businesses, that sort of thing. But their argument was, because of climate change, this is elevated to such an importance that we're now asking the court to recognize that the federal government has jurisdiction over those things. So I describe the carbon tax case as very much taking away powers that the province had prior to the Greenhouse Gas Pollution Pricing Act. So, I mean, that is the type of action by the federal government, which hopefully this bill can provide some assistance in dealing with in the future. So it's not about creating new powers for the province, but it's about trying to defend the powers that we already have.
And I'll add, if I may, Mr. Chair, I know that there have been a number of times that has been raised that somehow the decision in the carbon tax trumps all of our efforts to assert provincial jurisdiction, including under this Act. And I think Mr. McAdam can certainly elaborate on that further, but has already said as much, really, that there's nothing in the carbon tax decision which suggests that, says that in any way. It was a very narrow decision on price stringency. But in no place in that decision does it say that the federal government, for example, can continue to infringe on specific industries and provincial regulation affecting specific industries. That's very important. And again, I think partly to this point about, the economic tribunal and putting a dollar figure on some of these things, and then what one might do with that in terms of, there's been some speculation around what are the federal policies, regulations, legislation that might make their way through the tribunal. And I think, if anything, you know, and I hate to say this, but we're spoiled for choice. And at some point, when it comes to, you know, the methane regulations, for example, and the federal government, you know, prescribing equipment, and some of the other instances that I have cited, if we were to, for example, put through a number of these at one time, get a dollar figure amount on the harm, and then take that to, you know, interlocutory injunction, court of appeal reference, etc. At some point, one has to hope that, in light of the fact that the carbon tax decision was extremely narrow and really around the price stringency, and to Mr. McAdams' point, ultimately POG, peace, order, and good government, at some point a judge would have to say, this infringement over and over and over matters. It has an impact, and it can't be done. And it's been something that the courts have held consistently, for example, around the criminal law powers on infringing on specific industries and specific regulations with industries. They've been consistent in that, and that was one of the things I raised last week around the plastics intervention. It matters. These things matter. I believe they matter to the people of Saskatchewan. That where there is infringement, where there is living within a federation, working within a federation, being integrated within a federation, what's in the Constitution matters. And it makes us Canadian. Doesn't detract from being Canadian. It makes us Canadian. And certainly legally it has import that it can't continue to be this infringement over and over. It has too much effect.
Let's talk briefly about the carbon tax reference case, since you had mentioned it. Minister, do you believe that this legislation would have changed the outcome of the carbon tax reference case?
I'll certainly let Mitch weigh in on this. I think that it might have helped. It might have helped. I think that seen through the prism exclusively of 92A, and that exclusive, and it's been pointed out not only by me, I mean, a number of constitutional scholars have pointed out that the language exclusive is not by accident. And so if we had been able to suggest that in light of 92A, exclusive provincial jurisdiction, and all the powers that, if you know, all the, not only what Section 92A encompasses, but if we had been able to enumerate the core provincial powers that flow from that, which we have in this bill, and if we had then gone to interlocutory injunction and said, this is what we expect the harm will be, and we know what the harm is proving to be. And if we could have speculated that forward, and as I say, by independent assessment, said this is what we think this will lead to in terms of economic harm. And again, earlier I cited, you know, parliamentary budget officer, 28 million a year in grain drying alone, and so it goes. And it keeps going up every year. If we had been able to say to a court, could you please consider this under 92A, but also in terms of irreparable harm, I think that we might have improved the chances of it being seen through that prism, at any rate. And again, I mean, one of the things in terms of economic harm, and I mentioned, you know, Mr. Buffalo earlier, Stephen Buffalo, and talking about the impact of the carbon tax on Northern and Indigenous communities, and in light of that, I mean, he talks about the tax exemption and on reserves. And that the federal government is, of course, you know, continuing to say that people get the carbon tax back. But of course, most people living on reserve are exempt from paying income tax, so there are no rebates. So really, and this is to quote him, those who can least afford to pay the carbon tax are most likely to be excluded from the rebate. Economic harm. Economic harm to First Nations communities, Northern communities. And then there's the federal fuel standard and its impact on diesel. You know, driving conditions in remote communities require all-wheel drives. There are no EV charging stations. Economic harm. Electricity and heating, and Mr. Buffalo points this out, have become very expensive. On reserve, people have no control over whether their energy comes from diesel or natural gas or coal-fired plants. Bills have doubled and even tripled. That's not I saying that. It's Stephen Buffalo, economic harm. So there is an impact on federal policies on affordability of life and on our economy, period. And that's really what the Act is about addressing. So to the question about could this have been laid out, in arguing the carbon tax, I think now we look back and we say to a certain extent, we feel that it was the great impetus, or one of the great impetuses for where we find ourselves today.
What I would add to what the minister has said is I don't think this legislation would necessarily have changed the outcome in the carbon tax case, but I share her optimism that it might have helped a little bit. But maybe more directly to your question, there's nothing in this bill that purports to repeal or amend or change the federal government's power under the Peace, Order, and Good Government Clause of the Constitution, or the POG power. So that power will continue to exist, and the federal government can choose to rely upon it in a future case if they choose to do so. Now, in the carbon tax case, the Supreme Court was very careful in saying that is an exceptional power and that it should only be resorted to in exceptional cases, and they drew lines around it and very much circumscribed it, and I think gave clear signals to the federal government it's not something that should be resorted to often or willy-nilly or anything like that. It's a very serious power to resort to because of its impact on our Constitution. The only way that the POG power could be changed or eliminated from the Constitution would be an amendment that would require the consent of the federal government and 7 of the 10 provinces having at least 50% of the population of Canada. So that's under a different provision of the Constitution Act of 1982. So this bill doesn't propose to do that at all. But one of the other things that I would add where I think that this bill could have some impact on a case like the carbon tax in the future, a carbon tax case in the future, is, I think we've learned some lessons from that case. And one of them was we treated the case very much as a legal case, as a case that raised a question of law. And we very much tried to focus our arguments on the federalism aspect of the case. In our view, it wasn't about the environment or what needs to be done to combat climate change or who's doing enough or who's not doing enough. In our view, it was about federalism. And so we went into the case with the approach, this is a pure question of law. We're going to come in with our legal arguments. The federal government will come in with their legal arguments, and the judges will make their decision. So we didn't file any evidence with the court initially. The federal government then filed extensive evidence, and a lot of it was about climate change and the harms that will come from climate change. And a number of the interveners in the case, and there were a lot of them, also filed a lot of evidence about the impact that climate change will have on their communities. And then we filed some evidence in reply after that evidence had been filed, talking about the cost of the carbon tax on people and businesses in Saskatchewan. But we hadn't done that initially as part of our case. And I think that one of the things that this bill does by establishing the Economic Assessment Tribunal is it gives us a venue to go and seek that kind of economic assessment and get that sort of evidence. And as the minister has outlined, once the tribunal makes a decision, that decision can be used for a variety of things. I mean, it could be used for purely political purposes to go back to the federal government and say, here's what our tribunal has said. How are you going to amend or alter or respond to what's been said? It could also be used to bolster an application for an interlocutory injunction, or it could be filed as part of a reference case. So I think we have learned some lessons from the carbon tax case, and one of them is that we do need that kind of evidence if we're going to go to court again in the future and challenge federal legislation, and I think the tribunal will assist with that.
And I'll just add, if I Chair, very briefly, I think on the Economic Tribunal side of it, I mean, as I've said, independent assessment, federal government would be invited to submit information as well. One of the most curious things, and if we're going to really talk about making your case, making your argument, which I guess would suit our case or argument quite well, is that consistently where we say that the cost of a certain federal policy will be in the hundreds of millions, they often say it'll be higher. Federal fuel standard, classic instance. We filed, when I was Minister of Energy, numerous letters outlining the cost as we saw it. And the provincial government, I believe the latest number is 700 million or so. And I believe that was in the policy paper that's been referenced a number of times in the fall. And the federal government has actually come out a number of times in various contexts and suggested it could be much higher, as I've said. And again, this Just Transition report leaked about the impact, from the Federal Department of Natural Resources, and about how 3 million Canadians in the industrial workforce, and as I mentioned, agriculture, food processing, oil and gas, mining, manufacturing, and transport, will face what they call, quote unquote, significant disruptions. The whole purpose of this report to the Federal Minister of Energy was to outline potential cost, and clearly it was significant. And so I think that to Mr. McAdams' point about what the Economic Tribunal would achieve, what its goal would be, its goal would only be to put the dollar figure on some of these policies. But I think in many cases where you have the one who'd be arguing against you saying it would actually cost the province more, legally, surely that has some significance.
Minister, Section 3 attempts to give the Saskatchewan government exclusive control over regulating greenhouse gas emissions. How does that interplay with the carbon tax reference decision?
What I would say in response to that question is, this bill can't undo the decision that the Supreme Court has come down with. But the bill can state the views of the Legislative Assembly with respect to the jurisdiction that the province has. And as I indicated before, prior to the Greenhouse Gas Pollution Pricing Act and prior to the federal government relying on the peace order and good government clause of the Constitution to basically take powers away from the province clearly had that jurisdiction. So as I say, it doesn't undo the decision. The legislature can't undo a decision of the Supreme Court of Canada, but it does set out certainly what the case was before that decision, and it sets out the legislature's view on what we think is a very important topic.
Minister, you mentioned at length the Economic Impact Assessment Tribunal and how it would work. Can you explain why this process would be more beneficial than the traditional process of expert witnesses that you would normally gather and present evidence in due course?
Well, because I guess expert witnesses suggest that by default it would automatically go to a legal process or a court process, which it wouldn't necessarily. And as I've said a number of times, I think the important thing about the Economic Tribunal is that that's its sole remit to put a dollar figure on federal policies. And then what is done beyond that is potentially legal, but also informational. Again, with the policy paper before this bill came out, certainly there was an attempt, and in that case by Ministry of Finance officials, and to peg cost on some of these harmful policies. And as I say, I would take on anyone to suggest that those policies don't have that economic harm attached to them. I say bring that on. But be that as it may, the role of the Independent Economic Tribunal will be to assess, let's say, the proposed production caps on oil put forward by the federal government, still not really gazetted or clear. There are some, however, that are gazetted and clear, one of which is the federal fuel standard, which is going forward this year. The methane regulations, we have methane equivalency or equivalency with the federal government on our methane regulations. As that comes due, what they are actually envisaging will come with severe economic harm. One of which, and I've mentioned this a number of times, so Saskatchewan was publicly congratulated on its methane reduction by 50% last December by Minister Guilbeault. The federal government then turned around and said, well, you know, we see your 50%, let's make it 60 or 75 or whatever it's now become. That's not partnership. That's not collaboration. That's clearly economic harm. And one of the things that we've mentioned a number of times, and certainly I did, including to my federal counterpart, was the lack of data. Again, we're often told we should collaborate more with the federal government. I always say in counter to that, well, we do certainly where we can. But where the federal government does not provide simple data on how it is assessing us on things such as methane reduction, that was acknowledged, that was not acknowledged by my federal counterpart. In fact, he acknowledged that it made sense to ask for data if we're going to be working together. So I guess the point about the Economic Tribunal, that would be another thing that perhaps one would certainly raise. You know, we were congratulated for the 50% methane reduction, then they raised it to 65, now it's at wherever it is. We don't have any data or we get little shadows of data around how we're supposed to accomplish this. And the economic harm we see as this, plus we have the federal government jurisdictionally infringing in provincial regulations, which clearly courts have said they cannot do, to follow on everything Mr. McAdam has said. And then we come out with a dollar figure on the other end of it. It's not an easy task, but it's certainly doable. And then what we do with that information is potentially legal, potentially factual, potentially policy-driven, potentially many things, but it isn't only a legal process.
Minister, the Constitution at 92 sub 3 states, nothing in subsection 2 derogates from the authority of Parliament to enact laws in relation to the matters referred to in that subsection, and where such a law of Parliament and a law of a province conflict, the law of Parliament prevails to the extent of the conflict. How does this legislation interplay with that?
Mr. McAdam elaborate on that, but again, I mean, we've touched on this a number of times. I think how there are certain doctrines that have come to pass, including federal paramountcy, where there are also suggestions in the jurisprudence that it has gone too far, that federal paramountcy, when you have a conflict between the two jurisdictions, cannot be a hammer against provinces. And I think that, as Mr. McAdam has pointed out, I mean, the federal government did bring out the proverbial big guns when they brought out peace, order, and good government to trump provincial jurisdictions. So I'll let him elaborate further on the interplay, but it's certainly been a bit of a dynamic situation.
Thank you, Minister. I think the short answer to your question is that this bill doesn't affect the doctrine of federal paramountcy at all. And again, that's a constitutional principle that couldn't be amended as part of changes to a province's constitution. And that's what we're talking about here, is changes to the provincial constitution. So again, federal paramountcy is something that this bill doesn't purport to deal with and simply couldn't deal with.
Minister, you mentioned in your opening comments, and you've done a few times in the past as well, natural gas is the next federal government attack. Threats to our ability to use natural gases as a source of fuel and energy. Can you explain to the committee when the federal government said they planned to shut this down?
Clean electricity regulations that are currently in draft, that there'll be no fossil fuel generated power by 2035. The details of that are still forthcoming, but they are documented and known that that has been the intention, and that has certainly been the intention that has been signaled. I mean, we're waiting on the regulations, we're waiting on the explicit, line by line, as I say, stipulations under the clean electricity regulations. But in light of what we have heard and what we have been told and what we understand, that was certainly one of the overriding intentions. And again, that poses grave concern to us, of course, in light of our power mix and the fact that, for example, as I said in my opening remarks, natural gas powers the city of Saskatoon. We don't have that much hydro. The transition, if one wishes to call it that, between fossil fuel generation backfilled by wind and solar, awaiting SMRs, for example, small modular reactors, there is a gap. And as I say, the SaskPower president has said that non-fossil fuel generated power is literally impossible by 2035. So that's what I'm basing it on. And a number, obviously, have weighed in, including SaskPower, on the potential ramifications of the clean electricity regulations.
Thank you. I'd like to ask some questions about the Saskatchewan Act amendments specifically. Can you explain what these amendments have the effect of doing?
Mr. McAdams start, but certainly happy to.
I'm sorry, can you repeat the question?
Saskatchewan Act, what do they have the effect of doing?
The amendment to the Saskatchewan Act is an amendment to the province's constitution. So as I said earlier, we were very clear in saying that the province has jurisdiction under Section 45 of the Constitution Act 1982 to amend its own constitution. So the question then became, well, what is the province's constitution? And the obvious thing that we looked at there was the Saskatchewan Act of 1905. The Saskatchewan Act is a federal statute. It's the statute that created the province of Saskatchewan. But I need to be clear that the parts of the Saskatchewan Act are also parts of the Constitution of Canada. There are things in there that the province could not unilaterally amend, things like the borders of the province, the representation of the province in the House of Commons, things like that. But there are other parts of that statute that we believe are part of the constitution of the province and things that this legislature can amend unilaterally on its own without needing to go to Ottawa to get its consent. Now, an example of an amendment that was recently made with consent was the amendment last year to do away with the perpetual tax exemption of the Canadian Pacific Railway Company. And that was an amendment that was done bilaterally. It was done with the consent of the federal government. But in that case, we were dealing with a contract that had been entered into by the federal government, in fact, by the government of Sir John A. Macdonald back in the 1880s, that granted the CPR this tax exemption. So it was our view that that wasn't, because it was a federal contract that was the basis for the tax exemption, we couldn't unilaterally amend that provision. But when it comes to other parts of the Saskatchewan Act, it was our view that those are part of the constitution of the province and the province can unilaterally amend them. So what the amendment then says is, what we've talked about already. It asserts that the province has autonomy with respect to the matters that fall within our jurisdiction under the Constitution Act of 1867, where it sets out the division of powers between the federal and provincial government, with federal powers in Section 91, provincial powers in Section 92 and Section 92A. And I think how I described it a little bit earlier, it's sort of drawing that line in the sand, and it's trying to protect the jurisdiction that we have as opposed to creating new jurisdiction. So that's what I would describe as sort of the background to why we're amending the Saskatchewan Act of 1905 and what the effect of the amendment is.
fully want to understand the difference and why the process is different here than it was, as you mentioned, with the other provision that was recently changed. This one does not require, in your opinion, unilateral consent or consent of the federal government because it's only affecting Saskatchewan. Is that accurate?
And it doesn't affect those contractual rights. And there's other provisions in the Saskatchewan Act, like the boundaries is the easy example that we refer to. Saskatchewan couldn't unilaterally amend its boundaries because you would be affecting Manitoba or Alberta or the territory. So that's something that obviously you would need the concurrence of the federal government and the other provinces to do. But the amendment that's been included in the Saskatchewan First Act simply asserts that we have autonomy with respect to the matters that are already under our jurisdiction under the Constitution Act 1867. So we're not affecting federal powers, we're not affecting rights of an individual under a contract. The Hudson's Bay Company has rights under the Saskatchewan Act as well as the CPR used to, but we're not affecting any of those rights. We're simply making an assertion with respect to the province's jurisdiction, so we don't feel we need the consent or the concurrence of the federal government to make that kind of amendment.
So that's because we already have autonomy with respect to all of the matters falling under its exclusive legislative jurisdiction pursuant to the Act?
Well, I mean, as we've said, we're not purporting to give the province new powers. We're simply staking out the jurisdiction that we already have under the Constitution Act 1867. And I'm not going to repeat myself with the discussion that I had earlier about the carbon tax case and how in that case the federal government actually took powers away from the province. That was the effect of the decision in that case. So as I say, I see it as a bit of drawing the line in the sand.
Thank you. If the feds disagree with this assertion and your assertion on how this amendment has been presented, what is the advice that you've received on the success of that challenge?
Sorry, as I've said a number of times, Mr. Chair, the federal government has acknowledged it's constitutional. I know Minister Wilkinson has. I believe there was another minister who said it as well. And as I've said, in 2021, the Prime Minister explicitly stated that provinces have the power to unilaterally amend their constitutions. And I've quoted the Prime Minister a number of times. It's perfectly legitimate for a province to modify the section of the Constitution that applies specifically to them. There was quite a lot of speculation at the time, well, depending on whom you asked, vexation, puzzlement, because perhaps people there wasn't quite the recognition that this was something in provinces' powers to do, but Quebec did it, and it was acknowledged that they could do it, and there really has been no commentary by the federal government, to my knowledge, that this wasn't within our power to do. That's been broadly and largely acknowledged.
Minister, how would this provision stop the federal government from enacting valid federal legislation that would not be paramount in case of conflict?
Well, it doesn't prevent them from enacting anything. It is a tool at our disposal to challenge what they are enacting based on constitutional overreach and economic harm. And as I've said, I mean, federal fuel standard would be one example, set to come into effect this year, $700 million impact, at least, arguably more, according to the federal energy minister, and huge impact on agriculture, mining, fueling your car, heating your home, retail, transport sector, and of course, with all the trickle down, if you like, impacts of the carbon tax, and we've outlined that a number of times, about all the hits at all the levels in the supply chain. If this is, and it has been called carbon tax number 2, here we sort of go again. So they can gazette it and do it as they continue to do many things. But the quandary for provinces is whether it's the Environmental Impact Assessment Act, and as I've said, 10 provinces and territories joining us, and down the line there are many of these policies which have economic harm. It provides an opportunity for the province to assert the fact that exclusive jurisdiction under 92A actually means something, and to try to counter that infringement, which is frankly unconstitutional. But when we get into areas such, the number of policies that we're seeing, and it's interesting. I mean, one of the things that came up today at SARM, and a number of us were there. Of course, we heard the gentleman on the floor asking about, is the federal government coming after fertilizer next? And it's interesting because, people say, well, that's enumerated in the bill in terms of certainly of historical significance to the province. But it's actually interesting from a constitutional perspective too, because, the day-to-day business of farming, use of fertilizer, have been traditionally under the provincial realm, or so held to be. And so when the federal government comes along, and again, it's in a long litany of examples, they said, oh, it's all going to be voluntary with the sustainable agriculture policies, and don't worry, nothing to see here, all through the summer. And then right before Christmas, there was this intriguing line, which I'm sure members will be aware of, where I believe it was the federal agriculture minister, that there was a discussion paper that was put out. And in the discussion paper, it said explicitly that actually we could come after specific agricultural practices. And it's right there in black and white, right in the discussion paper. So I guess that signals and symbolizes why this act is important, because it might provide an opportunity to say, here we go again. What does that mean? What is the economic harm? What does that mean to producers? And yes, there's a concurrency over agriculture between the federal and provincial, but in light of day-to-day business of farming, and fertilizer use, you can't do this. And it's an important tool to that end, among many other policies that we see which are harmful.
Minister, I want to ask a few questions around the provisions around interjurisdictional immunity. Can you explain how you believe the province can enact provincial interjurisdictional immunity in legislation, as interjurisdictional immunity is a constitutional doctrine?
Certainly, Mr. McAdam can weigh in. It's not enacting interjurisdictional immunity. It's mentioning it along with core provincial powers, are sort of woven into the act, if you like, as terms which we felt, based on the jurisprudence, were important to integrate into the language because of some of the emerging jurisprudence around interjurisdictional immunity, the use of the word core in consideration by judges of exclusive jurisdiction. And I mentioned earlier that the hope perhaps is that the doctrine will make more headway. I referenced the case of PHS Community Services earlier, where the BC Court of Appeal was ready to make a determination, or signaled a readiness to make a determination in favor of the protection of provincial interjurisdictional immunity, and there was an emphasis in that case by the justice over the dangers of so-called cooperative federalism, which we certainly hear a lot about, having negative effects on provincial policies. That's pretty intriguing legally, and that's interesting certainly when it comes down to this concept of exclusive jurisdiction, but also what maybe interjurisdictional immunity could come to mean within that. And so that's why it was inserted. It was for the purposes of we hope, legal weight around terms such as core powers and interjurisdictional immunity. So I want to add anything.
What I would add to the answer given by the minister is, I think in order to answer the question, you really need to understand what interjurisdictional immunity is all about under the Constitution. And interjurisdictional immunity is one of the more obscure principles of the Constitution, and it's certainly one of the more difficult principles to understand. I know I've been to the law school a few times talking to law students, and I've said, if you can understand interjurisdictional immunity, you will pass constitutional law with flying colors. So I think to give a bit of background on interjurisdictional immunity and what it's all about, you have to kind of understand the division of powers generally. And so under the Constitution Act 1867, it says the federal government has certain powers and the provinces have certain powers. And the federal powers are primarily set out in Section 91, provincial powers set out in Section 92 and 92A. And the other thing that kind of gets overlooked sometimes in the discussion is that both Section 91 and 92A talk about those powers being exclusive. And I think in the early days of Confederation, back when the Privy Council was the final court deciding on issues with respect to the Constitution, exclusivity played a much bigger role. And the Privy Council would take an approach that basically there's a dividing line, and things are either within federal jurisdiction or they're within provincial jurisdiction. And that came to be referred to as the watertight compartments doctrine. What's in federal jurisdiction always is in federal jurisdiction, and what's in provincial jurisdiction is always in provincial jurisdiction. But over time, that's changed. And I think particularly after the Supreme Court of Canada became the final court of appeal for Canadian constitutional issues in 1949, I believe it was, maybe 47, the court began to recognize more and more that there were areas where jurisdiction was overlapping, where both the federal and the provincial governments could legitimately pass legislation dealing with essentially the same thing. And I mean, a good example of that would be the criminal law with respect to drinking and driving. That's clearly something that the federal government can pass laws about under the criminal law power, but the courts have recognized provinces have jurisdiction over highways, provinces have jurisdiction over property and civil rights. You can license drivers, and the provinces can suspend drivers if they're driving while impaired. So it's an area where you have both federal and provincial laws that can apply at the same time. And I know you had asked a little bit earlier about the doctrine of federal paramountcy, and that's where that doctrine comes in, where you have both federal and provincial laws applying. There needs to be some rule to deal with conflicts, that you can't have a provincial law saying do one thing and a federal law saying do something else. That simply, is unworkable. So we have the doctrine of federal paramountcy. So it means that where there are those conflicts, the federal law prevails and the provincial law becomes inoperative. But the Supreme Court has always defined the type of conflicts that will invoke the doctrine of paramountcy really narrowly. So it has to be something that's black and white. One law says yes, the other law says no, something like that. So you had this development or sort of evolution in the constitutional law, and we got to the point where courts were recognizing more and more overlapping powers. And then the court started to develop this doctrine of interjurisdictional immunity. And it basically says there are certain things with respect to the heads of power, and initially all the cases dealt with federal powers, so they were all under Section 91. There are certain things with respect to these federal powers that are so important that provincial laws shouldn't be able to affect them or touch them, even if there isn't a contradictory federal law that could be relied on for the doctrine of paramountcy. And the earlier cases dealt a lot with federal works and undertakings and, the application of provincial occupational health and safety laws, provincial labor laws, where you maybe had federal legislation, but it didn't cover the whole field. And the court said, well, no, it's interjurisdictional immunity. It's either a federal law or no law. And then in recent years, The courts have recognized that interjurisdictional immunity should apply to provincial powers as well, and the minister has referred to the one case where the Supreme Court explicitly said that, the Insight case, but that was a case that dealt with provincial jurisdiction over health, and the Supreme Court said, well, health is such a broad and amorphous topic, how can you decide what's sort of the core, or what's the key part of that jurisdiction for interjurisdictional immunity to apply to? But I think they've clearly left the door open for interjurisdictional immunity to apply to other more narrow and discrete provincial powers. And one of the powers that we think is a really good candidate for interjurisdictional immunity is Section 92A and natural resources, electricity generation, and those things, because it is more narrow and discrete. And then the next part of it that I think led to the bill dealing with interjurisdictional immunity comes back to something we talked about a little bit earlier about, like, how do you argue a constitutional case? And I was asked, well, how do you go in and argue interjurisdictional immunity? How do you say, well, this shouldn't be part of the core of that power, this should be part of the core? And again, those are hard arguments to make in court. We look at, history, we look at principles, and you try to make an argument the best you can based on those sorts of tools. But at the end of the day, it comes down to, it's either me standing in front of a judge telling the judge, well, I think this is why you should consider this to fall within the core, or why it shouldn't, or me or one of the other lawyers from my office. But it's just the lawyer in there saying that. So I think that this bill, by having the legislature of Saskatchewan saying, we think these are important topics, we think these things fall within the core of provincial jurisdiction, we think interjurisdictional immunity should apply, gives the government's lawyers, when we're in court, something to point to and say, it's not just me saying this, it's the legislature of Saskatchewan saying this. And so, like what we talked about earlier, we think it's an aid to interpretation. I mean, at the end of the day, ultimately judges will make the decision about what falls within interjurisdictional immunity and what doesn't. But we see the bill as helpful, as an aid to interpretation, as something that will be of assistance when we have to argue these cases in the future.
Thank you for that. Again, I go to the next question, which is, but is there any precedent for using this type of thing as an aid for an argument like this?
Yeah, as I said earlier, this is new and this is novel, and I can't point to any precedents where another province has done this or a court has issued a judgment saying, yes, this sort of clause can be used and relied upon. But that's sort of one of the things that's made this project really fun for the lawyers at the Ministry of Justice, because we are being creative, and we're trying to create something new, something that's no one's done before, and based on first principles and based on our understanding of constitutional law, the advice that we've given is that yes, this is constitutional. This is something that is going to be helpful, and in our view, it's something that should be done.
And I will add, if I could, Mr. Chair, too, I mean, just strictly speaking, I mean, we're talking on the interjurisdictional immunity side of things being, creative, new, somewhat new frontier. I mean, obviously not a 92A and those arguments, but I found it interesting. I mean, in the PHS Community Services case that we've referenced a few times, again, eventually went to the Supreme Court, but there was a lot of talk about delineating cores of provincial powers and the failure to do so in that case. And I think that's interesting and hopeful from our perspective, and the number of legal scholars who have supported the idea of provincial paramountcy in the sense of something to explore, to delve into, to begin to look at, in light of some of the things that Mr. McAdam has also raised, which is that perhaps the view is emergingly or somewhat between the lines, but emergingly, that perhaps the time has come to re-look at federal paramountcy as that hammer that it has been sometimes used as. And so for, you know, if we're going to look at exclusive jurisdiction under 92A, which is established, which is core, which is, the language is explicit for a reason, to that end, as Mr. McAdam has said, you know, interjurisdictional immunity perhaps buttresses that. The emerging view around federal paramountcy, core powers, enumerating what they are, all of this leads to trying to develop and enhance what exclusive jurisdiction means. Not that it really should need it, but it does. And I think that it's important to have done with this act.
Minister, I'd like to read an excerpt from a Supreme Court decision, and I'd like your comment on it and how it interplays with the legislation. This is the Reference Regenetic Non-Discrimination Act 2020 SCC 17 at paragraph 22. Quote, this court's approach to the division of powers has evolved to embrace the possibility of intergovernmental cooperation and overlap between valid exercises of provincial and federal authority. In keeping with the movement of constitutional law towards a more flexible view of federalism that reflects the political and cultural realities of Canadian society, the fixed watertight compartments approach has long since been overtaken and the doctrine of interjurisdictional immunity has been limited. Indeed, the more flexible principle of cooperative federalism and the doctrines of double aspect and paramountcy have been developed in part to account for the increasing complexity of modern society. The modern view of federalism accommodates overlapping jurisdiction and encourages intergovernmental cooperation.
Well, again, I'll certainly ask Mr. McAdam to weigh in. Again, I mean, I found it interesting that on cooperative federalism, and that does come up, I mean, obviously, in the context of discussion around something such as this, I mean, in the PHS Community Services case 2010, and I've raised this a number of times, the dangers of so-called cooperative federalism having negative effects on provincial policies was raised. So I think, you know, I mean, we can debate all night. Certainly we can banter back and forth around who has said what at what time around cooperative federalism, interjurisdictional immunity, core powers, federal paramountcy. But as I've said, I have found it interesting along this legal journey to explore and delve into what scholars are actually saying about federal paramountcy. The PHS case, the fact that cooperative federalism in its concept can be harmful to provincial policies, the fact that there has perhaps come to be a realization that federal paramountcy can be a hammer, that interjurisdictional immunity can also apply to provinces. I think these are things that certainly where we're talking about exclusive provincial jurisdiction under 92A have relevance. And I think that, I mean, we're clear on the fact, surely, that exclusive jurisdiction exists under 92A. This Act asserts that, and other arguments that we can make and use are strengtheners and potentially buttress cases, but I think that core remains of exclusive jurisdiction under 92A, and all that symbolizes and signifies for us economically and for us as a province and for us within the Federation and for us constitutionally. So again, anything you want to add on that?
Well, the decision from the Supreme Court in Reference Regenetic Non-Discrimination Act is an interesting decision. And the Attorney General of Saskatchewan intervened in that case. It was a case that deals with federal regulation of the insurance industry, and the regulation was justified as a matter of criminal law. It was our position that this represented federal overreach and that it was really simply an attempt to regulate the insurance industry, and that's a matter that falls within provincial jurisdiction. So it was a reference case that was initiated in Quebec. The Quebec Court of Appeal ruled in favor of the province and held that the act was unconstitutional. They wrote a very short, very strongly worded judgment that said to the federal government, you've overstepped your constitutional bounds with this legislation. The case got leave to appeal to the Supreme Court, and we intervened. And as I said, our argument was that this legislation overstepped federal bounds and should be struck down. I can tell you I was surprised at the Supreme Court's decision in this case. I was surprised that they found that the criminal law power extended to regulating insurance when they've been saying for a century that it doesn't. But the one thing that we've learned in constitutional law over the years is there's sort of a pendulum that swings back and forth over the decades from a court that is more favorable to federal jurisdiction versus more favorable to provincial jurisdiction. So you see swings in the cases, and you see cases that were unpredictable, and I think this one was unpredictable. The other thing that I would say about the court's comments about flexible federalism and cooperative federalism and recognizing that there are broad areas of overlapping jurisdiction, and that's absolutely consistent with what the court has said for a number of years. But the concern that we have with that is if you recognize that everything is concurrent, and the environment is a perfect example. If the federal government has jurisdiction to enact any law that it wishes because it deals with the environment, and you say, well, it's all concurrent power, ultimately the federal government has the trump card, and that trump card is the doctrine of federal paramountcy. So the more you recognize overlapping or concurrent powers, ultimately, at the end of the day, the federal government gets to call the shots because their legislation will prevail in the case of any conflict. So one of the things that we argued in the Genetic Non-Discrimination Act case was that the courts did need to remember that those powers in Section 91 and 92 are exclusive. And you know, I don't think we're advocating that we go back to the 1920s and have the Judicial Committee of the Privy Council as our final court of appeal anymore, but there were some things that they said about exclusivity of provincial powers, exclusivity of federal powers, that we still think have some validity today. So our concern is that, you know, if you see everything under the Constitution as concurrent or overlapping, then ultimately that's going to lead to centralization, and it's going to lead to a detraction in provincial powers and provincial jurisdiction because of that doctrine of federal paramountcy.
And if I might add, Mr. Chair, I think from perhaps slightly more of a political lens, but also of an economic reality lens. I mean, if we let that be the determining factor that, you know, federal paramountcy has been held to be, and that means collaborative federalism is what has been defined as being, and one can never push back and never challenge based on the exclusive jurisdictions we do have. I don't see how that's tenable in light of some of the infringements that we are seeing. That in other words, it's not worth it if that's in any way the suggestion, that because it's been held at some point or considered, surprisingly or not, that, you know, this impacts cooperative federalism or federal paramountcy applies, and so therefore we should just basically not challenge these things, whether legally or politically or economically, is the definition surely of defeatism. And there's a lot of effort to, I think that the most frustrating thing is this discrediting without factually outlining. And I don't mean so much on the legal side, I mean perhaps more on the, you know, on the policy paper side, or even on the constitutional side. Things are thrown out there, and you know, there's no factual outlining of the points. You can discredit easily if you don't say what you're discrediting and how and why. And so I think just as a conundrum, as an existential issue, as a province, you know, yes, on the legal side, but also on the economic impact side of these policies. It's called, you know, I hate the phrase, but every tool in the toolbox. And I think that's what we're really looking at here. And I think this is solid, that the bill is solid in all that it does constitutionally and asserts constitutionally. But also in every other aspect, we are left in a position where we simply must do everything we can to address this on an economic basis. And this is This is a means to that end. One means to an end being, interjurisdictional immunity and weaving that language in and core powers and enumerating core powers and asserting the core powers and the exclusive jurisdiction and amending the Constitution. Really, in many ways, there's not a lot more we could do to address this as an economic threat to the province. And that's really, I think, what we have to keep coming back to.
I'm not entirely sure, Minister, what you're referencing in regard to pulling things out of thin air. I was quoting a decision of the Supreme Court of Canada. And just to confirm, I very much appreciate your background on that particular decision, Mr. McAdam. But just to confirm, there is an understanding that the Supreme Court has been moving toward federal flexibility and a degree of overlapping jurisdiction. I'm seeing that was also quoted, not just in that decision with the Supreme Court, but also the greenhouse gas decision as well.
Yeah, I think as I indicated earlier, decisions in the Supreme Court are often hard to predict, and you can see trends over time where things swing back and forth between a more pro-provincial approach to a more pro-federal approach. Over the last 20 or 30 years, you have seen the Supreme Court advocating for overlapping powers, cooperative federalism, the things that you've talked about. But it's not universal or consistent, and I said earlier that the decision in the genetic non-discrimination reference case was a real surprise to me, and it was a case that was based on the federal government's criminal law power, and I'm not sure exactly how many years prior to that, probably 7 or 8 years prior to that, the Supreme Court had issued a decision in a reference case dealing with genetic reproduction, which was another federal bill that relied on their criminal law power to deal with a lot of matters that ordinarily would be seen to fall within provincial jurisdiction over health. And the Supreme Court struck that law down and said, well, no, this law has gone too far. You're encroaching on provincial jurisdiction. This is no longer valid criminal law. So I viewed that case as a narrowing of the federal criminal law power. So that's why I said I was surprised with the decision in the Genetic Non-Discrimination Act case, because it seemed to me to be a little bit out of step with their previous jurisprudence on the criminal law power. Now, whether it's a one-off or whether it signifies a shift in that pendulum is hard to tell. And the other thing that I would say about the decision in reference to the Greenhouse Gas Pollution Pricing Act, it's a real unique and special decision because it turned on the POG power, the peace, order, and good government power. There's a case, and the minister has alluded to it already, that's going to the Supreme Court next week dealing with the Impact Assessment Act. And it's a reference case out of Alberta. And the argument that Alberta made was that the new federal legislation dealing with environmental assessments was too broad, that it deals with matters falling within provincial jurisdiction. And again, I've said before, the courts have recognized that jurisdiction over the environment is divided. The way I've described it in court before, you need a hook to hang your hat on. So if it's a federal law with respect to an interprovincial pipeline, absolutely, they can deal with the environmental impacts of that. But in our view, the Impact Assessment Act goes far beyond that. And one of the things that the Act brings under federal jurisdiction is any provincial highway that's longer than 50 kilometers in length. So if the province decided we were going to build a new highway between Saskatoon and Regina, it would have to undergo a federal impact assessment. And that's whether it impacts migratory birds or fisheries or other things within federal jurisdiction. Simply because it's a road that's more than 50 kilometers long, the feds have said we have jurisdiction. And so the position that we're taking in that case is no, that's an overreach. You're overstepping your bounds. If it was just dealing with things like interprovincial pipelines or airlines or banks and post offices and military bases, all the other things within federal jurisdiction, it would be fine. But we've said there's overreach in that case. And as the minister alluded to, the Alberta Court of Appeal in pretty strong language found that the legislation did overreach. So I think that that case is going to be a much better indicator of sort of trends and where the Supreme Court is going on these things. And the federal government is not relying on the POG power in that case. It's a much more conventional argument based on the enumerated power set out in Section 91 of the Constitution Act of 1867. So I think the case next week that Tom Irvin from our office will be arguing will be a much better indicator of those trends.
Thank you for that. How does this legislation demonstrate bargaining in good faith with the federal government to address issues of common concern, intergenerational concerns like climate action?
Well, that's a big question, but I'll begin to answer it. I guess in terms of, if the question is about collaboration with the federal government in the environmental context, I've referenced a number of times. And first of all, let me say, and we say this often, and there was evidence of that last week in the discussions with the federal government on bail reform. The provinces had been united in their call to reform bail, to ask for reverse onus in certain cases based on the Premier's letter. It was they were absolutely united in terms of those efforts and that letter and that call. And that was followed up last week by the provinces being united in turn and going to Ottawa and saying, we need bail reform for all the reasons that have been gone through, including too many repeat violent offenders being released and some of the tragic cases we've seen around that in the country and following on that. And the federal government came to the table, and the federal minister came to the table with a commitment to undertake serious bail reform, to amend the criminal code, and acknowledge that this was an effort by all levels of government to get to that point. And that is significant. And so collaboration happens, and coming to the table happens. In terms of on the environmental side, again, if the suggestion is how does this signal good faith in terms of how we work with the federal government, I've talked about this a number of times. A good example is methane. We negotiated for 2 years with the federal government on equivalency for our methane action plan. And again, good faith, and we achieved equivalency in 2020 around our plan. So equivalency as in approval of our plan by the federal government. And the efforts that we've demonstrated around methane reduction have been significant. They've been noted, and I referenced earlier the public congratulation by the federal environment minister on our efforts achieved without assistance by the federal government, just on our own plan. And again, had, as I say, worked in good faith in collaboration with them to achieve equivalency on the methane action plan. And then, as I said earlier, there was a sort of turning of the tables in terms of, thanks for the 50%, but now let's make it 75 and so on. And I guess I would say, again, good faith doesn't only go one way, as in us to them. It goes the other way as well. And one of the examples I've raised, and I've raised it a number of times, including earlier this evening, is around the data side of something such as methane. You can't say to a province with whom you're hoping to work with honorably as a partner, do this and do this, but we won't share any of our data with you, or we'll share very little, or we'll be very selective. That's not cooperative federalism in the non-legal sense, or in the political sense. And we see that so often. We see the rules being changed, the expectations being changed, the boundaries being changed, and the implications of what cooperation means, which gets into, okay, well, if you cooperate, then we're going to impose this, 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 and this on you, and without real true collaboration. So I guess the act, and we've talked about this throughout the evening as well, Quebec, if we're going to talk about what Quebec does and how it amended its Constitution unilaterally and was acknowledged it could, it often collaborates with the federal government as a province. It often ideologically agrees with the federal government and yet feels it's very important to assert its exclusive jurisdiction and jurisdiction in other areas as well. And again, I don't think doing so makes you a better Canadian or a worse Canadian. I think it makes you Canadian. And certainly within the context of the Constitution, it's important, but also within the context of working together, provinces and the federal government. It has to be in good faith. And as I say, I think that the recent, and there have been a number of successes out of federal, provincial, territorial meetings in recent days. And I think the bail reform meeting was a noteworthy one from my perspective, because there was good faith and there were solutions that were offered and efforts to work together that were extended. And that's important, of course. But I don't think, nor has the federal government really suggested that this act is some kind of salvo that perhaps they weren't expecting. I mean, I think based on the interventions that we've made legally, but also interventions we've made politically around concerns we have on federal policies and economic impact and so on of those policies, I don't think it can be a terrible surprise that we're going down this road, or that we're exploring what we can do in the, within the legal context, for example, or constitutional context, because we've certainly signaled certain frustrations in other areas, but it doesn't diminish the opportunities where there are such to collaborate, of course, including on the environment. And we would say, and we often have said, if you as a federal government want to, if it's very important to you, for example, to go down the critical minerals road, because lithium is important for electric vehicles, and the world of critical minerals is opening up, and we don't want jurisdictions around the world who have fewer regulations than we do, fewer standards around the economy, around labor, around so many things that are transparent and strong and robust. We have said to the federal government, if some of these are areas that you're looking at exploring from your perspective economically, then you have to look at what Saskatchewan has to offer in terms of environmental sustainability, for example. I mean, that our potash mines emit, 50% fewer emissions than any competitor globally. That should matter. All of it should matter. And so I think that this certainly doesn't undermine anything we're doing on the environmental stewardship side. And as I say, I mentioned methane as one example, nor does it undermine the potential for future collaboration where we can act as honorable partners with each other. But it does signal, as Quebec has signaled, that exclusive jurisdiction matters and infringement happens and it has an effect.
I'm going to ask some questions around the tribunal specifically. Could you explain how the members of the tribunal will be selected?
Well, that's something that will be undertaken in the next few months in terms of best qualified people for that job, for that role. I have some in mind I think would be excellent. Whether they would be interested is the question, and there will be a process, of course, around that. I think, as we've signaled, independent and in terms of the assessment of dollar figure of some of these federal policies. And when I say I think of people who could be excellent, I think of people who would be extremely specialized and knowledgeable about some of the areas that are impacted. So, for example, methane, or in the federal fuel space, or agricultural sector potentially, depending on the acts that or the federal policies or regulation or legislation that actually end up going through the tribunal, whether it would be one, whether it'll be three, whether it'll be, that's all still to be determined, I think, in the next few months. So based on that, and then the specialization that would be required to assess economic harm of those federal policies, obviously there'll have to be a nimbleness in terms of who would be best placed to look at the dollar figure evaluation of, say, methane regulation overreach, or federal fuel standard, or sustainable agriculture policy, and or electric vehicles, or federal clean electricity regulations. You have to have someone obviously who has high specialization in power generation, or so it'll depend a bit on the act that goes, that the acts, or the policies that go through the tribunal, and will become more clear, I think, as the policies that we put through the tribunal are determined, and how we do that, and which go through first, and whether, as I say, it's one or a number.
Sorry, are you saying it's one or a number policies that you're going to be put forward through the tribunal, or one or a number groups that will form the tribunal? Could you clarify that?
One or a number policies that will go through the tribunal. It's still to be determined in terms of, for example, around the clean electricity regulations, it's, and I hate to say it, but, pretty outstanding candidate if in fact it ends up being clarified explicitly what no fossil fuel generated power by 2035 could mean. So if that becomes gazetted, if the regulations are released, then it becomes much more of a tangible thing to potentially consider for the tribunal. So no, the question would be more around whether it'll be one or a number, and then based on that decision or determination, then who would be best placed to evaluate and assess dollar figure on that said policy or policies moving through the tribunal. And that is still to be determined, largely because it's still to be determined exactly which federal policies would move through for consideration.
How be appointed to the tribunal?
The policies that we decide to have the tribunal hear. So that will be something that will be determined in the next few months in terms of, as I say, whether it would be one, and so the specialization that would be required with that. Obviously, there would be a chair. The more or less the idea would be a chair, and then perhaps two members who would be probably always present, or one would think for sort of the stability of the structure, permanent in that sense, and then potentially some with specialized knowledge, expertise in the area being considered. So as I say, if it were methane, it's different than power generation. So that has to be determined in terms of what policy we move through first.
Pursuant to the legislation, the tribunal members would hold office for a term not exceeding 3 years. I'm just trying to understand how, if you're going to have to, how far in advance you're going to have to know which policies you plan to have looked at by the tribunal to be able to make up the proper amount of types of experts that you're going to want to be able to do this type of work.
Thank you, Mr. Chair. Darcy McGovern. And to the member, I think the model that we're looking at, that's in the structure that you've mentioned, the chairperson presides over all meetings of the tribunal and is able to form a panel from a pool of people who have been identified. The 3-year term, which of course allows for reappointments for additional terms if necessary, shouldn't be an impediment in that regard, because we're talking about order and council appointments. So the minister's indicated that having identified experts in a particular subject matter area, those individuals could be appointed, and depending on the subject matters of the matters referred, might be used again, might not be particularly used again, depending on which matters come forward.
Thank you. Who's doing the identification of these individuals to be appointed to the tribunal?
I'll just start, and then certainly you can add anything. Again, it will depend now on, once the act is passed, the work on the tribunal begins, so there will be work done on structure, on candidate selection based on, as stated previously, the topic of the policies that are decided will go through for consideration by the tribunal. And so that work will now begin, and then will be subject, obviously, to ultimately cabinet decision in terms of, firstly, what policies will be considered and how and when, and then how we go about finding very specialized people who can assess the dollar impact of the federal policies.
Just to reiterate what you just said, Minister, Cabinet will be deciding both what policies will go forward and how, as well as who will comprise the membership of the tribunal.
So the federal initiatives are identified in the process for referral as set out in Section 6, defines federal initiative. It is referred under the terms of Section 8 to the tribunal. As a separate function, of course, the tribunal is appointed by members, is appointed by the Lieutenant Governor and Council, like the Farmland Security Board, like the Labour Relations Board, like any number of boards within government. That's the appointment process used to establish these. Your comment in terms of who these individuals might be, I think the minister's indicated it'll be affected by the subject matter, and of course, both through stakeholders and through the expertise of the various ministries who have been involved in these areas. We feel those areas will be obvious pools for helping with the identification of individuals who can best serve in this capacity.
I mean, obviously on the constitutional side, I mean, that would be an obvious proverbial skill set in terms of, what this means from, in terms of understanding, not so much weighing in, of course, on constitutional questions, but understanding what exclusive jurisdiction within the context of some of these natural resources and regulations and impacts of federal infringement on certain provincial regulations might mean coming from that perspective, and what's been perhaps found and looked at in other areas of the country and so on. So I think that would be helpful. But the hyper specialization of some of these areas is formidable, and I think that will take a little bit of time to establish in terms of, again, depending on the policies that we put through and that are decided that we put through, and in what order and how. It has something to do in some cases with timing federally. I mean, if you look at, as I say, the discussion paper around the sustainable agriculture side or potential, it's established only in a discussion paper at the moment. Some are very established, such as the Federal Fuel Standard, and some of what we're facing, for example, in the methane space, is very established. Others, such as the clean electricity regulations, have been signaled but aren't specific. So some of it in the next few months, I think, will be determined by that, just federal timing, federal clarity in terms of what actually is being proposed on the dotted line. And there are moving parts to some of these things around in a number of areas in terms of what the feds have signaled and what they actually then might do, regulations-wise or legislatively and otherwise. So, but I think that it's not to be underestimated. I mean, when you get into evaluating the impact of something such as the oil production cap that was signaled by the federal energy minister at COP and in Glasgow, there were extensive committee hearings. When was it? Last fall, federally. And no expert could agree what the impact would be. I mean, it went on and on and on. I mean, the transcripts are fascinating. They had academics and economists and all kinds of experts. And in terms of everything from cost to timelines, no one could settle on what this would mean. So obviously an existential threat to the energy sector if these were brought in. But even the federal government doesn't seem to know how this will work, when it'll come in, who's going to do it, And of course, then all the jurisdictional issues with that. So again, we have said, well, the oil production cap's a huge economic threat, but would it go through the tribunal in its very amorphous, vague form at the moment? Remains to be seen, I suppose, to a certain extent on what the federal government reveals in the next little while. But I think when you come to analyze economic harm of such things, you need very specialized people. You need very, very specialized people who I mean, I've seen that done by certain people in my former ministry, and you know, when you start getting into impacts of, I mean, it can get into impacts of individual wells and geology, and it's extremely specific, complicated work. So it requires very specialized people, and we want to make sure that they're chosen, you know, correctly and appropriately for the task at hand, which will be to evaluate economic harm.
Minister, you've mentioned a few times that this tribunal will be independent. Can you explain how you intend on ensuring that the tribunal is in fact independent?
Well, certainly I can, and Darcy, if you want to add anything. I think that once the appropriate people are put in place and the policy is provided for consideration, as I say, let's say the federal fuel standard as an example. Independent means independent. So it means that those people who are chosen to be on the tribunal, we can submit all kinds of numbers. We have, for example, on the federal fuel standard, and it's evolved and will have evolved, I'm sure, by that point, but we have pegged it at $700 million a year impact, at least, on the provincial economy. And we would invite, it would be then signaled that certainly whatever they need, and certainly would be open to them, presumably, to invite the federal government for their numbers, and whatever they would need to economically assess the impact of, let's say, as one example, the federal fuel standard. And then they would put a dollar figure on it, and we would see what they would say in that regard in terms of the assessment and evaluation to their mind of what this would cost the provincial economy, and that would be its remit. It's simple, but it's also complicated work, and so obviously that would have to be undertaken within the outlines of time and otherwise that we've put in the Act, but that it would have to be considered carefully and, as I say, independently, and that would be the absolute understanding.
And I think to add to what the minister has indicated, from a structural perspective, I draw the member's attention to 11.1 of the bill, you know, which does specifically provide that the tribunal is going to determine its own process, make its own rules to supplement the process, have the decision on terms of, you know, considering the referral with written or oral submissions or both. It also goes on in 11 to provide for certain powers in terms of the production of evidence, as well as the ability to enforce its functions through the contempt under the public inquiries approach if necessary. So those are the structural elements that you typically provide for an appointed tribunal to be able to operate independently, set its own rules and procedures, and then perform within its remit as the minister has outlined.
Appreciate that, but there's actually no independence in terms of who will form the tribunal. Why hasn't the minister put provisions into the legislation that would allow for independence at that stage as well?
In terms of who will form the tribunal, well, I mean, the tribunal is a creation, if you like, of the bill. And so the appointment of the individuals, and as I say, the goal will be to, in terms of some of the people, for example, who I think would be very excellent and are, I can't think of more independent people. And so I think I mean, the goal here is not to, would never be to subvert anything. It would be actual curiosity as to, genuine curiosity about what the dollar figure would be that would be landed on. I mean, I can say, for example, on the federal fuel standard that we have a very clear idea of what the dollar figure is, and in fact, the federal government has said it will be higher, as I've referenced. So I have not, I mean, if they came out and said, well, actually, there isn't going to be economic harm, that would be part of the fact finding. And so, but I do think that as per the OC order in council process, it's not certainly uncommon, and I think that in this case it would be to put the players in place for the tribunal, and then there are certain discretionary things that they then have beyond that, but certainly that which is fact-finding is up to them and their determination and discretion.
Thank you. And the reason why I raise that in particular is because you've mentioned this evening, Minister, that the findings in this tribunal will not necessarily simply be used just for perhaps evidence at a legal action, but it could be used for political purposes. And that's why the independence of this, and I would argue also the independence of those who are appointed to the tribunal is incredibly important. We're actually among the worst in the country in terms of across the board independence of tribunal appointments. We're a bit of an anomaly in that regard. So again, would the minister entertain, and I guess I'm sort of alluding to the amendments that I have that I will put before the committee, mostly are provisions that we feel would provide for a bit more of an independent tribunal process, in particular around the appointments. And again, I would ask why the minister chose not to put anything in this legislation at this time that would ensure a more independent tribunal appointment process.
Well, I guess I would say to that and when I said that it might not necessarily be used in a legal argument sense, I think that was to the member's question about why wouldn't it only be a legal context in which these things would be argued. So again, it's been a number of contexts this evening, but my point was not that it would politicize the tribunal. My point was that there would be a determination, and I think that's only responsible. I mean, I think that if the tribunal said that, or came out with a determination that the federal fuel standard, for example, would be a cost of $1.2 billion to the provincial economy, my point was that there would be an evaluation at that stage about what we next do with that information. And I don't mean to suggest, I only mean to suggest that it might be of factual relevance and information merely. Whether it would then necessarily lead to a case to the Court of Appeal, whether it would necessarily lead to an application for interlocutory injunction would be determined. And I think that's only fair. I think that the people of the province also don't expect that by its very nature it will go to a legal consideration every single time. And in fact, I've had to answer many times, is this just, do you see this as only a legal do you see this only as all next steps being legal? And I've said no. I think that in some cases it will be important to say this policy, clean electricity regulations, for example, is being found. It has been found or released or reported that it will cost X amount, and at the very least, the people of the province can take that on board and analyze it and discuss it and call for action or not. I think that the dollar figure could be eye-popping, but I think that that is up to the tribunal to put a dollar figure on, and that's its sole remit. And beyond that, as I've said, it could serve in terms of an interlocutory injunction, for example, which is very difficult to meet, and I've said that a number of times, and we've said this a number of times, but one of the thresholds or tests is irreparable harm. And irreparable harm is hard to prove, but I think that it could serve as that. But the purpose of the tribunal is only to come up with an objective finding about dollar figure or economic impact. And as I've said, that can be challenging. It requires specialization, but obviously also independence. And beyond that, then the determination would be potentially, to, as I say, get the word out even to the federal government about what the impacts are of some of these things on the provincial economy, on working together, and so on. So the range is only meant as a suggestion that there would be options that would be looked at, and that it wouldn't necessarily only go down a legal route. Anything you want to add, Darcy or mention?
Again, just on the structural side in terms of what we set up, and if we look at Section 10, what does provide an additional level of independence within the structure of the piece itself is that it's the chairperson who appoints the members of the tribunal to form a panel. And the members, of course, are aware that that's a structure that's used in other bodies where, for like the Labour Relations Board, for example, or the Highway Traffic Board, where you have a number of individuals that are appointed as members, and then you have a panel that's formed by the chairperson, not by the Order in Council. The Order in Council doesn't say, here's the panel. Instead, it establishes a panel of experts within an area, and then a particular referral. It may make sense from the chairperson's perspective who's going to be on the panel, whether it's to reflect certain skill sets in that regard. So, within that structure, and it's a common structure within highway traffic, farmland, surface rights, workers' comp, to have those these boards that we expect and watch operate independently, that they're appointed through this Lieutenant Governor and Council, Order in Council process. And certainly in this regard, nothing unusual is occurring in this case.
Does the minister have in mind a person for who will be appointed as the chairperson?
I have some people in mind who would be excellently suited, but there is a process, obviously, which we will have to undertake in terms of not only willingness, of course, but a decision by colleagues and by cabinet ultimately about who will serve on the tribunal. As I say, I can think of some who, if one were to state their names, their qualifications, would be beyond reproach, and that's the goal. Who could be absolutely deferred to and excellent if they were to undertake this, in terms of simply the specialization that's required, because, as I say, it is a very difficult undertaking, and a very extensive one, and requiring of high specialization.
What is the expected annual budget of the tribunal? Do you want to go?
It's difficult. And I think the minister's outlined some of the concerns. And you've heard me at this stage in the process before indicate that it's difficult to anticipate what a budget would be when you have such a range of how specific a particular referral might be versus how broad, and how many there might be in a particular year. I think it's what's fair to say, the reimbursement and remuneration for this group will be standardized. It'll be the PSC reimbursement rates, and as far as what they may on an annual basis be budgeted, it's a bit early to say because we're not really clear, as the minister's indicated, how many of these would occur. But what we can say, I think, is that it's clear that this is viewed as a priority, and that it's important to be able to have a flexible process that can accommodate these types of steps.
Thank you. And just so I know where to watch, will this budget be a line item that would come out of the Ministry of Justice?
That's always something that's going to be determined through the cabinet process yet, but certainly the minister has carriage of the bill at this point.
So that hasn't been decided yet? Will the tribunal only be looking at economic harm?
economic harm and economic impact. As I've said, putting a dollar figure on the federal policy before it.
Why didn't you, Minister, consider expanding the scope to include other types of harm beyond economic?
Fundamentally, this act is about protecting the economy, and it's at its act, it's about precisely that, the dollar figure impact of federal policies. And as I say, I mean, when I referenced earlier certain comments that were made by the member about the policy paper, I mean, it's the Ministry of Finance. So if we're talking about, you know, I think an unfair discrediting of those figures and reference to discrediting by others without, again, a real analysis back on where the finance ministry, actually didn't outline things as they should. I think it was, if anything, and has been stated, it could be much, much higher an impact. So the point of the policy paper was to attempt to put a dollar figure, certainly preliminarily, on the impact of some of these policies that were before us at the time. And some of them were evaluated according to dollar figure. Others are still to come, and still policies that, as I say, have yet to be gazetted, have yet to have regulations surrounding them, and so on. So that, you know, will be part of the work of the, you know, of the tribunal, not only to look at, in some cases, the numbers that have already been applied to some of these federal policies, but to potentially look at new dollar figures for new federal policies. But really, I mean, we've been consistent all the way along that the purpose of this bill is about preserving and protecting economic potential, economic growth, and really the economic breadth of the province. And so we felt that it was very consistent within that to say that a dollar figure and an economic financial impact assessment of policies would be of value in terms of what we were hoping to achieve, which was potentially challenging some of these based on exclusive jurisdiction under 92A and other areas, but really to have a very clean goal, as it were, of economic harm and economic impact, and that's really always been part of what the bill was about, identifying and in turn protecting when it came to infringement by the federal government. So that's always been a part of the tribunal as it's always been explained and envisaged.
To correct you yet again, Minister, the comments that were made at the beginning about the white paper were from letters that I had read into the record from Indigenous leadership.
No, I'll interrupt there, Mr. Chair. The comments made about the policy paper, and I don't know the exact quote, it was that basically it's been discredited or something to that effect, and that was not a read-in quote. It was a comment by the member, and I guess I would just say that I've said a number of times throughout the evening, I mean, I would be certainly, I think that those numbers are absolutely defendable. And where they have been questioned, it hasn't been explained why in any detail, certainly in any equivalent detail. And I think, though, that to the question about, you know, why the economic assessment of the tribunal, and economic impact assessment of the tribunal, it really builds on that work and that assessment that has already been done. And so certainly from the provincial perspective, it would be, you know, take said policy, white paper, policy paper has put a dollar figure of this on that policy. Subsequently, we have found this or outlined this or found this. Federal government would be invited, obviously, to also submit its information, and I think then hopefully we could come to a broader established understanding of the dollar figure. But it's the, you know, the importance of it, I think, speaks for itself, that really this is about economic harm and putting a dollar figure on it.
Again, those were literal letters I was just reading into the record, and if you have an issue with the content in any of those letters, I hope you do take it up with those Indigenous leaders directly. Minister, many will say that there is also an economic impact to doing nothing, especially in terms of climate change. Will the tribunal also be assessing that? Minister, will the tribunal have the necessary funding to investigate all aspects of any issue referred to it?
Well, I think we've answered that in terms of, I mean, first of all, we have to determine what policies will be put through the tribunal, and so we've talked a bit about that. And I think in terms of resources available to the tribunal, of course, we want to make sure that for the research that members of the tribunal have to do in regard to the micro details around costing some of these federal policies, of course, what they need in that regard, and that will involve primarily, you know, research abilities, opportunities for those tribunal members. I mean, in terms of information that's required, we will provide certainly all the information from our perspective about economic impact that, you know, and study of that we have done, and I've outlined that in a number of ways a number of times this evening. I mean, the federal fuel standard, for example, I mean, that work has been done. It hasn't been contradicted. In fact, we know the federal government has said it could be higher. So that's the sort of information, the record that we can provide in terms of the ways the ministries have delineated and outlined the cost of some of these programs, finance, energy, environment, and others. And so all of that will be, of course, provided, and anything that can be done in terms of assistance for you know, further information. Of course, you know, we want to make sure that there's that full ability for the tribunal and its members to do their job, and that will, of course, be honored and undertaken.
Mr. Chair, I really hate to do this, but this is the part of the evening where my the time of night and the dryness of the air starts to really do a number to my eyes. Can I have a quick 5-minute recess?
Yeah, absolutely. Yeah, we'll take a 5-minute recess and be back.
Okay.
Okay, I'd like to welcome everybody back, and we will go back to questions again. Questions, Ms. Sarr?
All for indulging me. Back to the tribunal. Will members of the public be able to make submissions to the tribunal?
Well, I think that remains to be seen, and as I've said a number of times, I think this is now the next stage, and obviously a very important stage, and one we take very seriously in terms of how this will then, now develop coming out of the Act as I say, a very important component of it. I think the plan as it currently stands is that specialized members of the tribunal will take a very detailed look, given those specializations, at economic harm and the dollar figure of federal policies. If, and again, it is speculative because we have to still decide what policy or policies will go through and in what order, and as I've said, when and how. But if, for example, you're looking at, and again, as I say, I emphasize the speculativeness of this, but if you are, for example, to look at EV regulations, for example, and the potential impact on the actual sale of those in the province. So again, a specific, sector, if you like, or section of the economy which is being directly impacted. It would be up to the tribunal, presumably, to canvass those who are on the ground in that area. And as I say, that would be one potential thing. And again, I say it again, it's very speculative. But I think the technical nature of some of these areas, if it's on the clean electricity regulation side and a move to no fossil fuel generated power by 2035, it's going to be different experts, different voices, different specialization than, EV regulation. And so I think there'll be a certain amount, I think the main goal really is to make sure that members of the tribunal have every means at their disposal to make the dollar figure determination. And I think that's very important and to their work and to their determination. So I think that if that would be necessary and that's what they would need to do in terms of canvassing players in certain sectors, for example, for a canvassing of economic impact, then I'm sure that would be something they could do and would want to do. So that's, I think, but as I say, at the moment, because we still have to determine to a certain extent, the policy or policies that move through, I think some of those things will become a bit more established as the policy or policies goes forward in terms of what the tribunal will need. I mean, again, I think it can be relatively simple in terms of structure. I mean, in an ideal world, if you can spend the number of weeks required to do the work required to establish the dollar figure, you don't need particularly fancy structure to do that. I mean, the work is very analytical and very in depth, but very concrete and meat and potatoes in the sense of establishing the dollar figure. So it would be what would be necessary to do that work. But if we look at, for example, the policy paper of last fall, I mean, that was undertaken by Ministry of Finance officials, and they did that in the context of their work, of their work description and of their workplace. And so in this case, while it isn't a ministry undertaking it, we would want to make sure that obviously they have what they need, but that it really is a matter of the facts at hand and establishing the facts at hand. That would be the remit.
Who will be notified of what topics the tribunal is looking into?
Well, go ahead.
I think once there's a referral made, that is, that's one of the benefits, I think, of this process is that it is a public process. An order in council is a public document. It is routinely made public. Where there's a referral to the tribunal, who gets appointed to the tribunal, those will be a matter of the public record, and that'll form part of what everyone's aware of in trying to make these assessments with respect to the economic impact.
The public will be aware of what work the tribunal is doing, but it will be up to the tribunal to decide whether or not the public can engage in that process. Is that correct?
Well, more or less. I mean, in the sense that, obviously it'll be public what policy we're putting to the tribunal. Because, as Mr. McGovern said, it's subject to OC as well as the appointments. And so, once it's determined that it's X policy that's going to be referred to the tribunal, it'll be very clear that the remit of the tribunal within the time frame that they have is to put a dollar figure on the said federal policy. And I'm sure there'll be some discussion about said federal policy in terms of, different perspectives on economic impact and dollar figure. Again, coming back to the federal fuel standard, $700 million at least from a provincial perspective, that's been documented. It's been publicly documented. We have sent public letters when I was energy minister to Minister O'Regan saying, here's the provincial impact, here's the dollar figure, could you pause this so that we have some established infrastructure in place, that we're not just importing product, biofuel from the US, for example. But obviously we have infrastructure coming online in terms of projects that have been announced that will be very active in this space. So there are things that are happening and the ways we can accommodate policy, and even ways that some industry players have already moved to do that. But my point is that it's all been very public in terms of what we feel the economic effect of some of these policies are. And in some cases, particularly maybe in emerging areas, in established areas such as the federal fuel standard, the tribunal might be able to say, well, actually, we think it's going to be much more or less, depending on when the infrastructure comes on within the province and the supply chain. But in an emerging area, such as the clean electricity regulations, or methane, if we don't achieve equivalency with the federal government, for example, I think there's a real role to establish dollar figure. And that's very important work, because that genuinely will assist us in terms of, assessing impact of these policies.
What requirements will be prescribed for an economic impact assessment?
Solid numbers. Solid numbers. As I say, that's been the remit. We've said that all the way along. I've said it all the way along from literally day one when we announced this in November, that the role of the Economic Tribunal will be to put a dollar figure on the federal policy. And it's not an opinion in terms of speculation or theoretical. It's a dollar figure. And as I say, the white paper did do evaluations, very thorough evaluations, of some policies at the point they were at that point. And this is going, by its very nature, these things have to be snapshots. But on the other hand, if you're looking at no fossil fuel generated power, for example, by 2035, that's a snapshot. But the snapshot includes, of course, some degree of estimating. And some degree of looking at what an estimation means, because if the transition, for example, to small modular reactors, as there's an attempt to backfill, there is significant harm. And so I think that would be informational, certainly, to have that assessed. And I think that's of value to us, it's a value to the people of the province, potentially it's a value to the federal government, that's the cost of some of these policies. And as I say, one of the most alarming things has been that around some of these policies, the signal has been, well, it's going to be actually much, much more expensive. And that I find alarming. And when it comes to, for example, the just transition, the vagueness, but at the same time the specificity of 3 million impacted. I mean, that's the natural resources number. That's not Saskatchewan or the Ministry of Finance or I saying it. It's Natural Resources Canada saying it, briefing a minister. So I think that there's a real need for clarity, and I think there's a real need for specificity, and that's going to be the role of the tribunal, to look at a policy and do everything it can to provide all of us with the economic impact of those policies.
Minister, what sort of rule-making powers are intended to be provided to the tribunal pursuant to Section 13?
And you're referring in 13 to TE, and what's looked at there, one of the things that we've been thinking about in that regard is that the report and the recommendations be subject to public disclosure. And so that having a report that has financial information that's considered confidential, for example, that the purpose of this process is very much to have a recommendation and a report that can be used as part of the public process. And so, for example, one of the things that we might look at there is to say that the tribunal, in preparing its report and its recommendations, should be mindful of it being a report that can be disclosed publicly.
Next question was whether or not these reports would be disclosed publicly.
Intention of the process is very much along that lines. Whether there's elements of the assessment that can't be because of, the confidential financial information. But I think that's the general idea. But certainly the report itself and the recommendations in general would be, and that's one of the things that the minister's been very clear on, that this is intended to be a public process to help with the public debate.
Right, and certainly, I mean, in terms of evaluating dollar figure to Mr. McGovern's point, I mean, there are companies whose financials, obviously, while they might be canvassed and provide information, I mean, there are always issues around some of that, especially when it gets into, specific financials for specific companies. I mean, there are companies and areas of some of the resource sectors which have made significant investments to attempt to accommodate federal policy, and again, that's a reality of some of the realities of the policies, but also of the direction of federal policy. And I think that one of the things that's very important is to not have members of sectors feel that they are being drawn into anything other than factual establishment of snapshot reality, impact to a given sector, to a certain direction based on federal policy at a given time. And I think that's important, because it makes the process very impartial and objective. If, for example, in evaluating an oil production cut, I mean, that gets pretty involved and in the weeds, and we encountered this, for example, during COVID, when companies had to go into negative production and so on. I mean, when it really gets into these assessments, as I've said, they're very, very detailed. But if it would be of assistance, for example, to the tribunal to presumably ask certain industry players, about direct economic impact, it would be up to them, I suppose, to evaluate how they want to best do that. But I think there have to be certain considerations, and this is something we'd have to evaluate as the process works through, given the policy that's being considered. But I think there'd have to be some awareness that some information is confidential, and so it would have to be within that realm to the end of producing a dollar figure.
Just to clarify, is it mandated pursuant to the legislation that the reports will be made publicly available, or is that a commitment from you, Minister?
Yeah, the report that's set out, it provides that the report of the tribunal is admissible as evidence. It doesn't speak specifically to the release points. So I think the minister's commitment with respect to how the report and recommendation is received has been stated.
And I believe certainly in terms of, you know, the dollar figure, the considerations, my only caution would be, and as I say, there would be no reason for it not to be public because we would all want to weigh in and discuss and analyze it and assess it. But my only rider would be on, for example, confidential, you know, business statements, financial statements, and so on, which one would have to be cautious about saying, yes, that will be revealed. There are considerations to take into account there, and we'll have to weigh that as we move into this process. But I think, as I say, the ultimate goal is dollar figure. And again, it's not as if this has not been done. It has been done. I mean, around the federal fuel standard. The Ministry of Energy and Resources, as one example, has done extensive work, and that has never been debated or disputed, including by the federal government. So the goal would be taking all of such information into account, presumably with the help of ministries, of course, because a lot of this work's been done. So they don't have to, you know, in some cases reinvent the wheel. But I think that, you know, obviously that the ministry has had, you know, information and been privy to information around specific industry players, and there are frameworks around how they deal with that and what they release publicly as ministries. And so we'd have to take those sensitivities into account. But aside from that, the dollar figure and, you know, the process as much as possible, and certainly the outcome should be known and discussed for all the reasons that we've talked about this evening, which is that it's of value to know what is arrived at for the purposes of evaluating the impact of these policies.
Thank you. I do have a few more questions in light of, but being cognizant of the time, I do, before I move away from the conversation around the tribunals, I do have 3 amendments that I intend to move at the appropriate time that I'm just going to mention briefly now, because they deal with the tribunal in particular. I will intend on moving an amendment that would require, it would amend Clause 10, and it would require the LG to appoint 1 member who is nominated by the Federation of Saskatchewan Indigenous Nations and 1 member who is nominated by the Métis Nation of Saskatchewan. My second amendment will be around witnesses and public input, so it would be amending Clause 11 by requiring that witnesses that would be summoned, assuming they would be summoned, would be treated the same as witnesses under Section 10 of the Public Inquiries Act, and that the tribunal must allow for public input as set out in Sections 5 and 8 of the Public Inquiries Act, and it would also strike out with the approval of the minister in subsection 11 sub 4, just for the hope and desire of creating a bit of a more independent process. The third and final amendment that I will move at the appropriate time would be to amend Clause 14 by adding the following: after council, after consulting with the Indigenous peoples of Saskatchewan in accordance with the province's constitutionally mandated duty to consult requirements. I just mentioned those now because we were on the topic of tribunals, but I do have a few more questions about a few other topics before I conclude. Minister, what do you say to those that feel the proposed act ignores the fact that environmental regulation in Canada has historically been a matter of shared jurisdiction between the Government of Canada and provincial governments?
I truly believe, Mr. Chair, that I have answered that extensively this evening. I can certainly go over it again in terms of collaborative efforts that we have made with the federal government and how that stands, our record stands. I'll go over it again. I mean, as I say, I've used the example of methane, where we negotiated for 2 years with the federal government to achieve equivalency. We achieved it. We reduced methane by 50%. We were congratulated, as I've said, by Minister Guilbeault on our feat. And the next move was to have us reduce it still further. We've had major challenges with obtaining data from the federal government with which we can establish where these reductions are supposed to come from their perspective. And so I guess nothing in the Act, and there's so many other areas, but nothing in this Act undermines either efforts on the provincial side to be environmental stewards. Again, as one example, the methane reduction of 50% last year, or areas where we can collaborate with the federal government, not only in the environmental sphere, but also in other areas. And I mentioned, for example, around bail reform just last week, where it was the federal minister who said that this was a group effort by all levels of government to get to this point. So those efforts happen, they continue to happen. There are challenges, there are some twists and turns, certainly depending on the area, but nothing in this Act undermines in any way, as I've said, either our efforts around environmental stewardship, and they are documented, whether in methane. The regulatory side is solid, it's robust, and is acknowledged as such. And the broader record, of entire sectors, such as 50% fewer emissions generated by the potash sector than any global competitor. And there are other areas. Natural Resources Canada itself acknowledged that emissions from the oil and gas sector had been relatively flat for 20 years. That was about a year ago. And so again, we would say, and we said at the time, if you are going to then cut oil production, how can you cut what by your own acknowledgement is flat? And so it goes. These are challenges that are raised and discussed, and I've raised this with federal counterparts, and they in turn raise things with me, and with the government. But I think there is, at its root, and I've said it a number of times this evening, this Act is about protecting environmental and economic potential of the province, but at its root, exclusive jurisdiction over the enumerated powers under 92A, which go to our provincial jurisdiction to allow our economy to grow for everyone. And I think that has always been the intention, and that which relates to other attendant areas such as the environment the undertakings remain the same, to be as robust and strong and sustainable as we've been and continue to be. And those is well documented, and the record is well documented. So it doesn't undermine any of that, and in fact is, I think, very clear on what provincial regulation means, in an area such as methane, for example, where it's been very, very strong and very, very successful. So that's, it's at its root really an economic protection bill.
What do you say to those who are concerned that this Act is an attack on greenhouse gas emission reduction policies?
It's simply not the case.
Do you feel the federal government should be shut out of regulating greenhouse gas emissions?
Again, Mr. Chair, we have canvassed that so repeatedly this evening. I think there are really complex, really nuanced arguments that have been raised, for example, around the carbon tax decision and under what auspice it was argued, and the fact that there were, there was really an attempt by the federal government to infringe on provincial jurisdiction through regulation, that they pulled out a peace order and good government, and you know, that subsequently there are other considerations in other acts, and most notably the Environmental Impact Assessment Act, which, you know, we feel is destructive and damaging. But again, I frankly forget the question. Would you like to continue?
Well, I think what I would say in response to the question is we wouldn't suggest that the federal government has no role to play with respect to environmental regulation. We accept that it's a matter of shared jurisdiction, and I think I talked earlier about the federal government can control the environment with respect to things that fall within Section 91 of the Constitution Act 1867, and the province gets to control the environment with respect to those things that fall within Section 92 of the Constitution Act 1867. So I think what we're really asking here is that, you know, the federal government keep to their lane and that we'll keep to our lane. And I'm a bit reluctant to go back to the carbon tax case again, but you know, I really do think that's a good example of a lack of cooperation by the federal government with respect to environmental protection issues and the regulation of greenhouse gases in particular. And I know that our current minister was not the Minister of Justice when that case was initiated, and therefore is probably not as familiar with the details as some of the other folks. And there had been the pan-Canadian framework that had been agreed to by most provinces. There were discussions between the federal government and the provinces about how to achieve certain goals for reducing greenhouse gas emissions, and the understanding was that different provinces would be able to adopt different approaches. Each jurisdiction would be able to achieve those goals in ways that satisfied its own local needs. And if you'll recall, the Minister of Environment at the time, who's now Premier Moe, was at a meeting with his provincial colleagues in Quebec or someplace down east when the federal government unilaterally announced what was referred to as the backstop at that time. So they said every province has to have a carbon tax. It has to be the same as British Columbia's carbon tax, so it has to apply to the same items. It has to be the same amount or the same stringency. And what they also said is that if you don't do it, we'll impose it on you. And I remember when we were first asked about that in the Constitutional Law Branch, that was shocking, that the federal government was going to impose a carbon tax on provinces that didn't follow their backstop. And if you'll remember, when we initiated the carbon tax case, the backstop was only going to apply in Saskatchewan. We were the only province at that time that this legislation was going to apply to. So I was reminded as we talked tonight, and you've referred a few times to cooperative federalism. I remember one of my colleagues who was working on the carbon tax case with me coined the phrase, this is coercive federalism, it's not cooperative federalism. So, I mean, yes, we certainly recognize that the federal government has jurisdiction with respect to the environment, but our concern is in that example, in that case, they overstepped that jurisdiction, and I think that this bill is intended to try to provide some assurance that that doesn't happen again in the future.
Conclude my questions. I have a couple comments, and I'm sure, Minister, you'll have a few closing comments as well. Before I get started on those, so I don't forget, I just want to take a moment and thank you, all of the officials, you three in particular, for being here this evening and helping answer the questions tonight. I very much appreciate it, and very much appreciate all the work that you do every day within the Ministry of Justice. Thank you so much for your service. I wanted to flag, first of all, one particular person I forgot to mention who's spoken up about this bill that deserves mentioning, who I missed in my initial remarks, which is the Assembly of First Nations National Chief, Roseanne Archibald, who back in December said she supports First Nations leaders and in their calls for a resolution to reject both the Saskatchewan First Act here and then the Sovereignty Act in Alberta. And she said, quote, "These two acts are really seeking to extend provincial authority into federal and treaty jurisdiction and therefore are interfering with treaty lands," end quote. We've had extensive conversations about a lot of things with respect to this legislation this evening, and I do appreciate the time to have those conversations. As is mentioned a few times tonight, this bill is a statement. Its legal weight at this point in time is unsure at best. There's no real precedent for this. This is very novel. The concern is that this has been sold as something much more substantial to the public than what it is in reality. We are very much in favor of asserting ourselves and our constitutional rights as a province, but we are not in favor of PR stunts. If the minister feels that a federal policy or legislation infringes on the Charter, then they should challenge it, like the ministry has always done. Saskatchewan people, workers, producers, and manufacturers want to see a government that both protects our natural resources while ensuring we are doing our part to preserve our planet for future generations. This bill does neither. What this bill has done, however, has reversed the clock on reconciliation in Saskatchewan. It has offended Indigenous and Métis leadership throughout the province and damaged their trust and relationship with this provincial government. Do not bother to even reach out to First Nations and Métis leaders when contemplating introducing a bill that could affect the Constitution prior to the introduction of the bill is and was both disrespectful and arrogant, which left them feeling like an afterthought. As a result, although we will be proposing amendments to the tribunal, and we do appreciate Mr. LeMaide's, the member from Athabasca's amendment, apologies, it's very late, which we will support. We will not be supporting this bill because of that.
Comments, Ms. Saar. Any closing comments on Bill 88, Minister?
Sure. Thank you, Mr. Chair. And I think that if the last 5 hours show anything, and some of the nuance, the knowledge that Mr. McAdam, for example, has brought to the perspective of some of the underlying issues of this constitutionally, whether we've talked about interjurisdictional immunity, core powers, what 92A means, what exclusive jurisdiction means, that is not a stunt. That is substantive. And I will say I was Energy Minister, of course, for 4.5 years, and it was something I will always remember as extremely valuable and certainly an honor. And I heard all the time about the importance of the resource sector for First Nations, for the province, but for First Nations. And to claim, as has been claimed at least once this evening, that there is no benefit to these communities from the approach that we undertake to take in terms of valuing those sectors is, certainly regrettable. I think top of mind, it really is all about working with First Nations communities to create opportunities for growth, for economic well-being, and we've talked about a lot of things this evening, but I think of, having been with MLTC, a Middle Lake Tribal Council a few weeks ago, the biomass project. And I mean, that again is an example of some federal components, of course, but also a climate provincially and a partnership and incredible potential and potentially incredible impact. And so when we talk about the importance of these things, it is not glib and it is not a stunt. It is fundamental to our economy and to our identity economically as a province. And those opportunities, of course, are not only in the energy sector. They're in forestry, they're in mining, and we've talked about some of them. There are emerging areas coming on board. And I think of, and I've quoted him before, Chief Sheldon Watney, who said that we're not, quote, against development because we understand many of our people make their living from the resource sector. And they do. And when I testified before the Senate a few years ago on the Environmental Impact Assessment Act, Bill C-69, and its impact to the province, I emphasized the importance to senators of mining, for example, to the north. And I told the Council of Chiefs Conference on Energy in 2019, it was just before COVID, that it is our First Nations communities who hold the key to the success of pipeline and other resource projects. And we see that again and again. And the theme of that conference was how energy projects can defeat First Nations and on reserve policy can defeat First Nations, rather, on reserve poverty. And I certainly agree with that. And we'll just say that when you look at the natural resource sector, the mining and oil and gas sectors combined employed about 2,000 First Nations people last year, 9%, forestry 30% or upward of that. There's so much opportunity, there's so much promise ahead. And I think intrinsic to all of this that we've talked about tonight is that Section 35 explicitly enshrines treaty rights, so does all provincial legislation, so does this. And the amendment brought forward a few hours ago now, certainly if it reassures and clarifies, then absolutely it is welcome, more than welcome. But it is already something that has been enshrined. So I think that, you know, it's been a discussion certainly in high detail about constitutional and other aspects to this, but they are real and they are substantive. And certainly I'm proud of the bill and would like to also thank officials, of course, Mr. McAdam in particular, because he's always front and center with me on this. And it is, I think, a very, very solid attempt by us as a province to address that which needs to be addressed for the protection of the economy of this province. Thank you.
Thank you, Minister. We'll now move on to Bill number 88, the Saskatchewan First Act, Clause 1, short title. Is that agreed? Carried on division.
Yep, it's carried. So,
Yeah.
yep.
Yeah. Oops. Clause 2. I recognize Mr. Lemay.
I have an amendment for Clause 2, amend Clause 2 of printed bill in the heading by adding and non-abrogation after purpose. B, by renumbering it as subsection 2.1 and by adding the following subsection after subsection 1. Subsection 2, nothing in this act abrogates or derogates from the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada that are recognized and affirmed by Section 35 of the Constitution Act of 1982. I so move.
Yeah, that's carried.
Okay. Mr. Lemay has moved the amendment to Clause 2. Do committee members agree with the amendment as read? Agreed. Carried. Is Clause 2 as amended agreed? On,
Okay,
carried on division.
Sign. Date. Right, carried.
Division.
No, that's okay. Here, got an initial this side.
Clause 3. It's underneath it.
Yeah. Clause 3 is agreed.
Clause 3, is that agreed? Carried.
One division.
One division. Clause 4,
Recognize Mr.
I
Lemay.
recognize Mr. Lemay.
I have an amendment for Clause 4, amend Clause 4 of the printed bill by adding the following after Section 3 of the Saskatchewan Act, A in the English version, and by adding the following clause, and B in the French version. Here's my attempt to speak French. Autonomie de la Saskatchewan. La Saskatchewan jeu d'autonomie en trois matières relevant de son champ des compétences législatives exclusives en vertu de la loi constitutionnelle de 1867. Les Saskatchewan est dépendé comme depuis toujours de l'agriculture. On s'occupe du développement de ces ressources naturelles non renouvelables, de ces ressources forestières et de la production d'énergie électrique. La capacité de la Saskatchewan de contrôler le développement de ces ressources naturelles non renouvelables, de ces ressources forestières et de la production d'énergie électrique as correspond de la très et le prospère futur de la Saskatchewan et de sa population. I so move.
Mr. Lemay has moved, oh, sorry. Wait. Mr. Lemay has moved the amendment to Clause 4. Do committee members agree with the amendment as read? Carried. Is Clause 4 as amended agreed? Carried on division.
Sign.
Sign this.
Yep.
Wow. Okay. I recognize Mr. Lemay.
I have an amendment for Class 5, amend Class 5 of the printed bill. A, by adding the following after Section 90Q2 of the Constitution Act of 1867, A in the English version, and B by adding the following after Clause A, and B in the French version, 7 Saskatchewan, 90S.11, la Saskatchewan joue de nous atomer en trois matières relevantes de son champ des compétences législatives exclusives en vertu de la présente loi. 2. La Saskatchewan est dépendée comme depuis toujours de l'agriculture en ce qui du développement de ses ressources natural, non-renewable, de ces ressources forestières et de la production de l'énergie électrique. 3. La capacité de la Saskatchewan de contrôler le développement de ces ressources naturelles naturelles non renouvelables, déchets, ressources forestry, état de la production d'énergie électrique est crucial pour le bien-être et la prospère future de la Saskatchewan et de ses populations. I so move.
Mr. Lemay has moved an amendment to Clause 5. Do committee members agree with the amendment as read? Carried. Is Clause 5 as amended agreed? Carried by division. Okay. Clause 6, is that agreed? Carried on division. Okay, just sign here, right across. 7, is that agreed? Carried on division. Clause 8, is that agreed? Carried on division. Clause 9, is that agreed? Carried on division. Clause 10, Ms. Sauer.
I'd like to move an amendment and amend Clause 10 of the printed bill by adding the following subsections. Sub 2.1, the Lieutenant Governor in Council shall appoint one member who is nominated by the Federation of Saskatchewan Indigenous Nations. 2.2, the Lieutenant Governor in Council shall appoint one member who is nominated by the Métis Nation Saskatchewan.
Ms. Sauer has moved an amendment to Clause 10. Do committee members agree with the amendment as read?
This clause, we will continue.
This amendment is defeated. We will continue with the original Clause 10. Is that agreed? Carried on division.
Right, defeated.
Clause 11. Ms. Sauer.
I'd like to amend Clause 11 of the printed bill, Sub A, by adding the following after the Public Inquiries Act 2013 in subsection 11 sub 2. Quote, and witnesses summoned under the powers of Section 11 will be treated the same as witnesses under Section 10 of the Public Inquiries Act 2013, end quote. B, by striking out, quote, with the approval of the minister, end quote, in subsection 11 sub 4. C, by adding the following subsection after subsection 11 sub 4, quote, sub 5, in addition to the powers conferred on it by the Act, the tribunal must allow for public input as set out in sections 5 and 8 of the Public Inquiries Act 2013. So move.
to Clause 11. Do committee members agree with the amendment as read? The amendment is defeated. We will continue with the original clause. Clause 11, is that agreed? Carried.
On division.
With opposition.
On division.
On division, sorry. Yeah. Sorry. Okay, another sign here. Clause 12, is that agreed? Agreed. Carried on division. Clause 13, is that agreed? Carried on division. Clause 14 coming into force. Ms. Sarr?
Mr. Chair, I'd like to amend Clause 14 of the printed bill by adding the following after council. Quote, after consulting with the Indigenous peoples of Saskatchewan in accordance with the province's constitutionally mandated duty to consult requirements, end quote. I so move.
Ms. Sarr has moved an amendment to Clause 14. Do committee members agree with the amendment as read? The amendment is defeated. We will continue with the original clause. Clause 14, is that agreed? Agreed with division? Carried on division? By and with the advice and consent of the Legislative Assembly of Saskatchewan enacts as follows. The Saskatchewan First Act.
Sign right across. His Majesty right across here. Full signature.
Full name.
Yep. Sign right at the top.
I would ask a member to move that we report Bill number 88, the Saskatchewan First Act, with amendment. Do I have? Mr. Gruel has moved. Is that agreed? Carried. We will move on to the next bill, Bill number 102, Constitutional Questions Amendment Act 2022, a bilingual bill. We will begin with Clause 1, short title. Minister, you may make your opening comments, please.
Thank you, Mr. Chair. I'm pleased to offer opening remarks on Bill 102, as stated, the Constitutional Questions Amendment Act 2022. This bill amends the Constitutional Questions Act 2012 to ensure that the Attorney General receives notice of a challenge being made to a provincial law under the Saskatchewan Human Rights Code 2018. Currently, where a provincial law is challenged for its constitutionality, the Attorney General is given notice pursuant to this Act. However, where the validity of a provincial act is challenged under the Saskatchewan Human Rights Code 2018, notice is not provided to the Attorney General. Mr. Chair, the proposed amendments will ensure that the Attorney General is given notice, the opportunity to make submissions, and standing where an application is made under Section 52 of the Saskatchewan Human Rights Code 2018. This bill will also update language in the Act to remove pronouns and refer instead to the title of the official. And with these opening remarks, Mr. Speaker, I welcome questions respecting Bill 102, the Constitutional Questions Amendment Act 2020.
Thank you, Minister. We're open for questions. Ms. Sarr.
Mr. Chair, and thank you, Minister, for your opening remarks. Just a few questions on this. Why didn't this provision exist before?
It's more a matter of it simply hadn't been coming up. in 1982, with the charter, of course, the charter became what was commonly pled. It was usually what was raised in court, and the Bill of Rights wasn't raised as often. More recently, this was brought to the attention of the constitutional branch that there were people who had based their claim on the Constitution Act, on the Saskatchewan Human Rights Act, which could invalidate an act, and therefore, of course, we don't take the invalidation of an act passed by this Assembly lightly, and it's something that's appropriate for notice. So it was more a matter that it hadn't been included at the time of 1982, and it simply hadn't been identified as a problem. Once it was, the constitutional branch indicated we should step forward.
Just to clarify what you just stated, I believe what triggered this was the Constitutional Law Branch became aware that there had been some instances where legislation had been challenged, but they hadn't been given notice?
It was being raised as an issue, and they became aware. There wasn't actually a case that went through as much as it was that it was avoiding that surprise in the future and avoiding that problem.
So this is a proactive response?
A preventative measure.
Okay. No further questions.
Thank you, Ms. Saar. We're going to move on to Clause 1, short title. Is that agreed? Carried. Clause 2, short title. Is that agreed? Oh.
Clause 2, is that agreed?
Yeah, I was going to, is that agreed? That's what I was going to say.
Okay, yeah.
Clause 2, is that agreed? Carried. Clause 3, is that agreed? Carried. Clause 4, is that agreed? Carried. Clause 5, is that agreed? Carried. Clause 6, is that agreed? Carried. Clause 7.
We'll have to come back to these.
Clause 7, is that agreed? Carried. Clause 8, is that agreed? Carried. Clause 9, is that agreed? Carried. Clause 10, coming into force, is that agreed? Carried. His Majesty, by and with the advice and consent of the Legislative Assembly of Saskatchewan, enacts as follows: the Constitutional Questions Amendments Act 2022, a bilingual bill.
Yeah.
I'd ask a member to move that we report Bill number 102, Constitutional Questions Amendment Act 2022, a bilingual bill, without amendment. Mr. McLeod moves. Is that agreed? Carried. That completes our committee business for tonight. I'd like to thank myself as chair. I'd like to thank the minister and her help today for all the work they've done. The opposition minister, or member, sorry. Look at that, I gave you a promotion too. And to all committee members, thank you for all your work today. Any closing remarks by the minister?
Thank you, Mr. Chair. It's been a relatively long evening.
Opposition member, not minister.
Just an echo of thanks to everybody who made this committee possible today.
Thank you. I'd ask a member to move a motion of adjournment. Mr. Kiesig has moved. All agreed? Carried. The committee stands adjourned to the call of the chair.